Lordship, may I be allowed to mention? May I be allowed to mention one matter, Your Lordship? Item number, Lordship, upgradation 104, Your Lordship, today's list, Lordship.
Why?
Since Your Lordship, the petitioner is the Your Lordship participant, Your Lordship, in a recruitment process conducted by the Your Lordship Public Service Commissions under the Your Lordship Fire Departments. Now, the Your Lordship, the
Process has concluded.
no, Your Lordship is about to conclude, Your Lordship. So that is the urgency. The on the last occasion, Your Lordship was taken up the matter, where Your Lordship the matter primary question of law, which was framed, Your Lordship, that whether Your Lordship that the certificate OBC certificate can accepted after closing of the date of the Your Lordship notifications. That was the Your Lordship the issue, which
Give
was
it Monday. It will be taken.
okay, grateful, Your Lordship.
My lord, may I permitted to mention, my lord, item number 158, my lord.
Why?
My lord, that is a motion matter, my lord, but my lord, matter listed in item number 158, my lord.
We'll see. No upgradation. Sorry.
That is a first time matter, my lord, the matter will come, my lord.
Call the list.
Item number 1.
Tribunal has allowed. Last year also there was no. Second.
Petitioner before your lordship is a land user candidate, lordship. He applied to the authority for land user. There is a notification for grant of employment as a land user candidate. There is a notification. But the land tribunal passed this order only to consider this case. Consider the directing the authority to consider the representation pending before him.
Please place para 3 of the tribunal's order.
Lordship. মুড়ে রাখলাম কোথায় গেল Lordship, come to page 44.
Please read para 3 of the tribunal's order.
Only
Please read paragraph 3 of the tribunal's order, sir.
Lordship, paragraph 4 of the order.
Please read paragraph 3, sir.
Paragraph 3.
Yes.
Paragraph 3, Learned Counsel for the applicant, after arguing for some time, submit that the applicant will be satisfied if the appropriate direction be issued upon the respondent to consider his pending representation dated such and such.
Then what is the tribunal to do? Take down. That
Perfect.
Item number 2,
My lord, one thing, my lord, one thing, I pray, my lord.
Next case, sir.
Yeah.
Next case. Sorry,
Aadhaar
your
case, my
case
lord.
is over. Next
Your
case.
Your Lordship, I appear for the appellants. I was praying not today and tomorrow because I'm suffering from fever.
Let it come tomorrow with a note not to.
My other side is here.
But I'm appearing on behalf of the respondent applicant, my lord.
If it could be
Come
taken up on
tomorrow with
Monday.
a note not today. Next.
My
3,
Your Lordship, I am for the petitioners. My Lord, I have filed this writ petition, my Lord, against the orders passed by the Honorable AFT, my Lord.
Fresh service.
My Lord, service has been affected, my Lord, but yesterday night I had checked, I could not affirm the affidavit of.
So you complete it, then only it can be considered.
My Lord, let it be taken up on the next week, my Lord, any day. Great.
item number 4,
My lord, just yesterday we have received the brief. I am
for the
applying for only 7 days accommodation.
Let us see.
But in this case, challenging the transfer order, my lord. Transfer order, page number 23.
But where is the transfer order? Which
Transfer
page?
order, page number 23, my lord. Page number 23. Prior to the date of transfer, my lord, on 7th. Oh, yes.
What could have been R2? R2.
Yes. Yes, my lord. The transfer order is nullified in tenants because he is not the administrative arm, my lord. The transfer has been done on, order has been done on 3/8/25, my lord. Prior to the date of transfer, my lord, page number 21 and 22, he has been released, my lord. Before the transfer order, he has been released. Number one. Number two, my lord, it is a transfer is one division to another division. My lord, Sialda to Malda division. But without the consent of the zonal railway authority, that cannot be done. And my lord, not only that, in the
You have
at
not
that
said
time at the
anything.
transfer,
You have not said anything like that in your OA. Where have you said in your OA? that it cannot be done by the without consent of the
No,
zonal head.
already, my lord, in the rejoinder also, my lord, there is stated it.
Rejoinder in the tribunal.
Yes. That was in page number 101, the rejoinder, my lord.
The rejoinder, you cannot make out a new case.
106, my lord, the transfer from Sialda division to Malda division of the administrative interest for the period of 5 years. And not only that, the transfer was
106.
106, my lord.
Where you have said it is without approval of the competent authority. Read.
The MOCP, that the MOCP has been here, that the DRM is the paragraph 5 and the annexure by mark has, it is very much clear that the temporary transfer of the post of the non-gazetted staff from the DRM it has full power to, we have challenge and control by them. But in my case, in the transfer order, annexure for the original application, it is duly mentioned that it should be transferred from Sialda division to Malda division on the administrative interest for the period of 5 years, and which is clear vehement violation of the MSOP F25 item number 3A, and which is no proper justification in the eye of law. It is also mentioned that the here in the contents of para 3, the MSOP of 25 and the Sialda division can be decision of the transfer of the non-gazetted staff within the ambit of the Sialda division. But only the Sialda division that can be transferred. But when another division, one division to another division, that the headquarters approval is required. Not only that, my lord, in page 23, my lord, transfer order itself is stated, my lord.
Where is MSOP 25?
Yes.
Where is the MSOP?
MSOP has been stated.
Where is it?
It is not available today, my lord. Today is the first day. And
just because you say it is violative, it becomes violative.
It has been stated in the.
We don't believe it.
But on the transfer order,
if you are sanguine that there is such a provision, you would have annexed it. You are not annexed it. That means it is not a reliable statement.
My lord, in the transfer order, your lordship can see, my lord, 23.
Yes.
My lord, on approval of the competent authority, DRM.
We are not going to look into that. You have no authority to change.
No, the transfer order is for 5 years with post, my lord.
Yes.
Well, if the transfer has been ordered with the post, how the lien has been taken, my lord?
What is the ground? There is no ground for challenging.
Now, when the transfer has been made with the post.
No, some akshat. Sorry.
No, my transfer order has been taken by page number 23, my lord.
How many times you will show page 20?
On approval of the competent authority,
Yes.
with the head, with the finance concurrent, Sri Shantanu Mahapato level 6, who was ordered transfer along with the post of Malda division for 5 years. But once they have transferred with the post for 5 years, and now in the last portion, the period of 8-3 issued the waiting for final release from the division, the lien of the staff will be maintained. And how the lien will be staff would be maintained, my lord?
Nothing. You have said nothing like this in your OA. Whatever you are arguing, there is nothing in the OA to this extent. OA is only that some officer, you are saying he has threatened you, and because of that the transfer has taken place. That is all. That is your case, nothing else.
The transfer order is to be, my lord, the bona fide intention. It is the bona fide intention.
No, where is the law that transfer has to be bona fide transfer order and the court has to see whether the transfer order is bona fide?
The transfer order, prior to the date of transfer order, he has been released. What is the motive of the administration, my lord? Then how the administration can say that the administrative interest, my lord?
Third Learned Counsel for the
Five.
then only we can have some say. I don't think
5 I am for the respondent, lordship. Lordship 5 I am for the respondent. I am praying for 1 week time.
My lord, I am assailing the, my lord, impugned order dated.
You are for? And he is for?
I am for the respondent, all the respondents.
Which
There
respondent?
are only 4 respondents. my lord.
Indian Council of Agriculture Research, lordship, and all. I am the principal party. I am praying for 1 week time, lordship.
You are appearing for which respondent, sir? We are asking you.
Respondent, sir. all the respondent, Indian Council of Agriculture Research, Lordship. All the parties.
Sir, item number টা একটু চেক করুন স্যার, এটা item number 5.
Oh, item number 5, Lordship, not item number 5. Samrat Chatterjee, I am appearing the Central Administrative Tribunal also in this matter. Item 5.
My lord, not that critical matter, my lord.
Keep myself order. I have got research yesterday. I have got the instruction.
There is a learned counsel who is appearing here with instructions in court.
Union of India has nothing to do in this matter. Union of India has nothing to do in this matter because this matter related to Tribunal Central Youth Research Institute, the organization of the ICAR. I am for the ICAR. To arrest
Bijoy Kumar.
I say Union of India has nothing to do with this matter. Vijay Kumar. I appear in the cat was in the cat. I appear and this matter was done by me in the cat. Central Administrative Tribunal.
Well, I am also, my lord, I can.
No, you are not in the we are in deal with this situation very difficult. We don't want to show me. Just don't know how to deal with it. What is to be done?
Adjourn could
Please talk to him.
not talk to him, talk to the. I will talk to the office because there is a junior advocate also. I will
Did not say this thing.
ওদের ঝামেলা জোর হয়ে গেল একটা লোকের দুটো হয় না দুটো বলছি একসাথে চলে এসছে হ্যাঁ আপনি আছেন মুরলীধর মুরলীধর
Item number 6.
মুরলীধর
Kindly paying for Passover, my lord.
For the petition.
I am for the petition. That last day, my lord, when the matter was taken up, I relied on a rule, my lord, it was passed way back in 1965, my lord, covering, my lord, the recruitment with regard to the appointment to the post of, my lord, drug inspector. My lord, I said that the qualification.
This is for the first time it has come.
No, 6, item number 6, you will see.
No, it's a fresh case.
Shubhadeep Ghosh, Chaudhary. Shubhadeep Chaudhary matter was mentioned. It was directly to be posted to on this day. Shubhadeep. It was mentioned.
It was mentioned, but it has come up for the first time. The petitioner's name is different from what you are saying.
What are you saying?
It's Chandramani Pakira.
Oh, this is also mine.
Good for you. But this has come for the first time.
Yes, yes.
Perhaps he had mentioned it that it was supposed to be. This is the matter that you had mentioned.
Yes, yes.
WPST 40. No, this is different. Anyway,
What is it?
what is the issue here?
Here, issue, my lord, the order of for my lord, supplementary affidavit, my lord, I am filing. My lord, I have missed out, my lord, the reply that was submitted by the central government.
Tribunal has rejected your application.
I tell your lordship, my lord, senior audit officer, a lady, my lord, whose husband, my lord, my husband is a government teacher of a government sponsored school. Now, 2012, my lord, the appointment was made. I stayed in Kerala, 2012 to 2017. On the basis of my transfer, I cannot place the, my lord, the application for my transfer on the ground of spouse and my mother's illness, my lord. I cannot, but the transfer was effected from Kerala to Kolkata, Barakpur. Now, 2014, my lord, I was asked to, my lord, fill up an option form indicating, my lord, the choices, my lord. My lord, I exercised my option. Now, my lord, after that, 24, my lord, November, they passed an order. They retained me. After 6 months, they passed an order of transfer, transferring me from Calcutta to Shillong. I made a representation. That representation was not considered. I approached the Honorable Tribunal. The Honorable Tribunal, my lord, was kind enough to set aside the order of transfer, remanded back to the authority to reconsider, my lord, possibly in the context of, my lord, the transfer policy and the other factors. My lord, it is not unnecessary to mention that, my lord, the other 50 employees, 50 numbers are employees, they, my lord, were retained by the office, my lord, and they were senior to me. The tribunal, when second time, my lord, I approached the Honorable, ultimately
Representation was rejected.
this was rejected. I approached the Honorable Tribunal in the month of March 2025. On 9th June 2025, my lord, the matter was considered, and the tribunal, the Honorable Single Judge, my lord, was kind enough to hold that the transfer order was absolutely in order, and there is no point for interference. Now, my lord, the subject matter, my lord, I have one weak point that in response to the reply, my lord, that was submitted by the authority, I did not file my rejoinder. So, my lord, today there are certain questions of law. Number one, my lord, I seek leave, my lord. Today, just now, my lord, I have filed the supplementary affidavit annexing the reply, my lord, filed before the tribunal by the central government. This is nothing new. So, my lord, if your lordships grant me leave. Now, my lord, this is
Supplementary affidavit taken on record. Yes.
Now, my lord, today, my lord, I would like to place before your lordship
Can we see the disposal of representation first?
Disposal of representation was.
Where is that? Can we see that before we proceed? On what ground the representation has been not allowed? Where is the disposal of the representation? Which page?
Yes. Oh, 130, which was imputed before the tribunal.
Yes.
My name featured, my lord, in serial number 14, page 131.
Can you read this page?
Sorry, my lord.
Has been considered but not acceded to. However, deferment has been granted.
3 to 5. Huh?
First paragraph.
Regarding transfer order, official respondent at that serial number 1 to 2. Oh, this one. Officials mentioned in serial number
1 to 2 has been considered.
3 to 24. The competent authority of the headquarters office has considered their application regarding transfer order, but not acceded to. However, deferment has been granted by the headquarters for officials, serial number 3 to 5, mentioned against their names. Mine is, my lord, I featured in serial number.
What does deferment mean?
Deferment means, my lord, it is a postponement or, my lord, kept in abeyance in a way.
So for the moment, they are not required to act upon. It is deferred.
Deferred. That is, and deferment
So
up
1 to 5.
but for a period 30th June 2025. This was, my lord,
This is, you are not covered by this deferment.
I am not. Certainly not.
So you are covered by the not acceded to.
Not acceded to. Huh? The next speaking order, my lord, the second one, after the tribunal had set aside 4/3/2025, page 242 of the writ petition. Page 242. This is the first order. Representation to representation.
My lord, I am appearing for the union of India.
এগুলো কি অ্যাপয়েন্টমেন্ট লেটার? এরকম দেখাতে নেই অ্যাপয়েন্টমেন্ট, রেখে দাও, পকেটে রেখে দাও, তোমার কোনো বিকল্প নেই। কপি কি গো? ওই এনভেলপে দিতে হবে গভর্নমেন্টের ইনস্ট্রাকশন ফর সিকিউর পেপার।
Yes.
Now, my lord, the tribunal, my lord, affirmed the, my lord, the reasoning that weighed with the authority. Now, my lord, I require, my lord's kind attention to page 145. It, my lord, delineates, my lord, the contour of the transfer, which is in a way essentially a transfer policy. My lord, kindly comes to page 145 first. My lord's got it, my lord.
Yes.
This is, my lord, way back issued, my lord, 28 March 2014. Only paragraph 2, my lord. The competent authority has approved the transfer policy as contained in the enclosed annexure to be followed by CGDA office and filled such and such while carrying out transfer of the members of the department, excluding IDS officer, from one station to another. The transfer cases already finalized will not be reopened on the basis of the provisions of this policy. Next, my lord, page 146. What is the scope? Clause, my lord, 1.11. The criteria laid down in the succeeding paragraphs will be observed by the headquarters and field peer controllers and controllers in effecting transfer of staff within their jurisdiction. Transfers ordered on administrative/disciplinary or compassionate grounds and that of new recruits will be outside the purview of the transfer policy. 1.4. Main intention of transfer of staff should be to repatriate individuals serving at tenure and difficult station to give all members a chance to serve at popular stations of their choice as far as possible and to shift individuals and employed on sensitive assignments after completion of the prescribed tenure. Next, 2.1, categorization of stations and tenures. All stations where offices of the department, including headquarters of the controllers, are located will be categorized under the following two broad categories. Hard/tenure stations, those stations where there is a lack of normal amenities of life due to difficult condition of service, etc., which are therefore very unpopular with the staff, will be identified. And fixed hard tenure stations, cities with a considerable population having schools, colleges, hospital will not be categorized as hard tenure stations merely because of staff or a section of staff is reluctant to serve there. Others. The rest of the stations will be categorized as other stations, and from among these stations, PCDA, DCS will identify popular stations posting to which are in great demand. Some of these popular stations will be carefully centrally controlled and posting to this will be made by the CGDS office only. Their status as centrally controlled will be reviewed periodically based on the number of volunteers applying the stations. Tenure will be fixed for hard tenure stations. An individual who completes the prescribed tenure at a hard tenure station will be transferred out except otherwise provided for. The normal tenure in other officer stations shall be 3 years. However, PCS CDS will have the discretion to reduce the period but not below 2 years in exceptional cases with due regard to all relevant factors such as degree of unpopularity of the station, difficulty in finding suitable replacement, etc., or on other compassionate grounds or administrative exigencies. The period of rotation of staff in other station need not be fixed or inelastic. continuance of an individual at these stations beyond 3 years is subject to overriding conditions, that is, it's not necessary to immediately transfer him or her to meet a requirement elsewhere, and B, there is no legitimate claimant for the station where he is serving. Now, my lord, 5, page 148. I am not placed at the heart station at now, Miller, at present, Miller. So, to fill up,
you are in an other station.
yeah, this is absolutely, Miller. I am deeply obliged. To fill up clause 5, transfer from other stations. Transfer from other than hard/tenure stations will be effected in the following circumstances. To fill up the vacancies at hard tenure stations, the selection being made in accordance with the criteria prescribed in 4. To meet the shortages in another station / accommodate volunteers, if a selection has to be made from among a number of individuals serving at various other stations who have completed their tenure, the criteria for selection will be length of service at their presentations beyond the minimum stay prescribed. 4 says, Millard, selection of staff for manning vacancies at hard/tenure station will be made from amongst the following: volunteers for that station, station seniors who have never served at hard tenure stations or interstate seniority basis, determined on the basis of length of service as present stations beyond the minimum tenure prescribed. 3, individuals who have completed their tenure at other stations and had served earlier at a hard tenure station for the prescribed period. The criterion for selection will be the same as laid down above, except the person who had served earliest at a hard tenure station will be moved first. Now, Millard, page 149, clause 3 says, if number of such individuals is appreciable, their transfers may be effected convenient batches strictly on the basis of the seniority of service of the stations. 7.8, exemption from transfer or deferment. Exemptions / deferment may be considered in the following circumstances. In case where an employee or a member of his family is suffering from serious affirmation such as cancer, polio, blindness, mental, psychiatric disorder, paralysis, and are differently able, such and such may at their discretion grant exemption from transfers for a specified limited period, provided the disease is certified by the authorized specialist and supported by medical documents. The case will be reviewed before the period of exemption is over. 4, on educational grounds where the child is in 10th and 12th, single parents of the children up to 18 years of age. 8.2, where both an husband and wife are serving in the department, they shall be posted to the same station as far administratively possible, keeping in view of the DAPT on subject. Husband and wife teams, when one of them is serving outside the department under the central government department, public sector undertaking, state governments, may, as far possible within the constraint of administrative convenience, as stated above, may be considered for posting at the same station, or if there is no vacancy / post in that station to the state where the other spouse is posted, there shall also be governed as per DOPT guidelines on the subject, as far as administrative feasible. Where for the administrative reason it is not possible to accommodate the spouse in the place of posting in the husband or wife, preference shall be given in the repatriation to the place of posting of the spouse upon completion of 2 years. Last, Millard, 9. This is, Millard, the promotion will not automatically. So, cares 8.6. Care will be taken to post ladies at a station of their choice or at a convenient distance from the station of present posting, to the extent feasible. In such cases, they shall also be eligible for repatriation to their choice station upon completion of 2 years, and priority shall be given to such cases. And Millard, it says 12.3, page 152, where intercommand transfer of staff are effected on station seniority basis, efforts will be made to post them with the same region subject to availability of the vacancies. Now, Millard, I must tell your lordship, Millard, the Honorable Tribunal, Millard, directed the central government, Millard, the respondent, to clarify, although it is not recorded, as to why the others, Millard, those who are senior to me and Millard, they have been posted in the office, Millard, for a long period. Why they have not transferred? The answer, Millard, in the affidavit. Page 12 of the supplementary affidavit. 15 below, sorry, it is a 1-5. 1-5. Millard, only 2 clauses, which according to my humble understanding, Millard, does 15. Each and may I read for my lords? Each and every case of 50 personnel have been examined through Defense Account Placement Board. Their applications are considered by DAPB. As of present, respondent finally get approved by the competent authority. Therefore, no irregularities are there in the transfer process. However, all exemption on some grounds are subject to verification in every subsequent DAPB where the specific matter is placed. Therefore, exemption is not forever. Subject to examination by DAPB on the basis of the present condition whenever the concerned case is placed before the DAPB, which may be occurred at the several occasions in a year, at least once in a year during the consideration of the seniority basis transfer from a particular station. Moreover, no decision to provide exemption from transfer is arbitrary or discretionary, but on the basis of consideration of the extant rule position in this regard. Not a single case out of 50 got exemption on spouse ground, which is the main ground of the present. Spouse ground is already enumerated, and why the others have been considered, it cannot be said, my lord, by an authority before a constitutional court, my lord, or the tribunal, salutary authority, which is the constitutional remedy, that they said the applications are considered by the DAPB as of the respondent and finally get approved by the competent authority. Therefore, my lord, it means that since they have approved without disclosing the reason why they have been approved in the affidavit or in the order, that means, my lord, they are not required to supply any reasons. And no single case out of got exception on the spouse ground. Spouse ground, my lord, I have said that is in the transfer policy. And my ailing parents, my lord, I have said, my husband is an employee of a government-sponsored school. My lord, that is also there, who is posted in the, my lord, the same district. So these considerations, my lord, not wait neither with the, my lord, the authority. The question is, my lord, that the representation and my lord, and my lord, if your lordships kindly, my lord, have the charity to consider 30 to 38, your lordships will be pleased to find that I will not burden your lordships with, my lord, the tiring repetitions, but if your lordships kindly have a cursory glance, your lordship will be pleased to find that all the employees, the 50 employees prepared by me, my lord, the list of the officials who have not been transferred till date under PCDA, they are all senior to me. And my lord,
to that effect, I shall submit the documents which is confidential. Department has instructed me to submit before your lords. That 50%, list of 50%.
Yes. He could not understand the mind of the court as yet. Oh, sure. Now, my lord,
till now, we also don't know what is going on in our.
That is a blessing for us, my lord. I don't. Now, my lord,
we have seen the hardship. We have seen your claim is based on hardship.
Not only yes, hardship will not emanate
from of many dimensions. Your son's or daughter's education, your parents' illness, and my being a female, and your husband's post.
And policies, my lord, these hardships are not unknown, or my lord, it cannot be said by any such organization that these hardships were not considered or countenanced by the policy. Then, my lord, the question is the reflection of mind with regard to the seniority requirement as reflected in the policy. My lord, these considerations with evidence must, my lord, come before your lordships, that these are the reasons. Now, my lord, the policy, my lord, which takes notes of, my lord, the hardships, which standing on the floor of, my lord, 3 pillars. Number 1, my lord, my husband, my child, my ailing parents. Second, my lord, the seniority and the requirement of the staff. My lord, it is not like this that I feel that these persons are required to be transferred and DAPB has approved this, but without the reasons have not been shown. I take it, my lord, for a moment that in the affidavit the government has sought to, my lord, elaborate or elucidate, my lord, the reasons which do not find place, my lord, in the impugned order. And, my lord, the government in its affidavit did not, my lord, paint the reasons, my lord, in any form.
Which was the provision?
Because, my lord, requirement of transfer and
Where-
intercession.
Where was the provision regarding seniority?
Yes, requirement of seniority, intercessionarity, and individual hardship. That is, my lord, 140, page, clause 4, page 148. Requirement of transfer, intercessionarity of present, clause 4.
Clause 4.
Selection of staff for manning vacant, page 148. Selection of staff for manning vacancies at hard/tenuous station will be made from amongst volunteers for the station seniors who have never served at hard or tenuous station on intercessionarity basis, determined on the basis of length of service at present stations beyond the minimum tenure prescribed. C. Individuals who have completed their tenure at this other stations and had served earlier at a hard tenure station for the prescribed period. The criterion for selection will be the same as laid down above, except that person who had served earliest at hard tenure stations will be moved first. Then, Miller, 5. To fill up vacancies as hard tenure station, the selection being made in accordance with the criteria prescribed in para 4, which I have just read. To meet the shortages in another station, accommodate volunteers. If a selection has to be made from among a number of individuals serving at various other stations who have completed their tenure, the criteria for selection will be length of service at their presentation beyond the minimum stay prescribed. And, Miller, and 2.3, page 147, the normal tenure in other offices, but I will start reading, Millard, from middle. The period for rotation of staff in other stations need not be fixed or inelastic. Continuance of an individual at these stations beyond 3 years is subject to overriding conditions that it is not.
Rest we remember you have placed. We are just looking. The rest you have already placed.
Yes, and Millard, it is not inelastic. Now the question, Millard, might crop up in the mind of the court, Millard, that if I join, what is the consequence? If I join, the policy says, Millard, you cannot
join.
No. Millard, the policy, only I have to stay there for 2 years. This policy cannot be banned. This policy cannot be relaxed if I join there. Now the question is that, Millard, why it is, Millard, malafide? Because, Millard, the answer has been given by the Honorable Supreme Court, 2014, 3 SCC, page 799, paragraph 30, 44, 45, 46.
You are relying on Somesh Tiwari. You are relying upon Somesh Tiwari judgment.
Shivanandan, that is, Millard, Shivanandan, City and others was High Court, Kerala and others. 40 and 44. My laptop. And is it a case, Millard? I do not know. Subject to, I put this question, that if someone, Millard, has already, Millard, made a bridge between the higher authority or the main in higher echelon, that he or she wants to come back from Shillong to Kolkata. And in order to accommodate he or she, her, Millard, the particular person, Millard, the transfer was necessary, so far as I am concerned. If someone from Shillong, the administrative exigencies within the scope and ambit of clause 4 and 5, these are all absent. And page 40, paragraph 40, Millard, the principle of fairness in action requires that public authorities be held accountable for their representations, since the state has a profound impact on the lives of the citizens. Good administration requires public authorities to act in a predictable manner and honor the promises made or practices established, unless there is a good reason not to do it. I stop here, Millard. The standard, last paragraph, it says, Millard, that whether, Millard, that relevant material was placed before the court, that the decision was in public interest. This standard is consistent with the principles of good administration, which requires the state action must be held to scrupulous standards to prevent misuse of public power, ensure fairness to citizens. 44, my lord, in a constitutional system rooted in the rule of law, the discretion available with public authorities is confines within clearly defined limits. The primary principle underpinning the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle or rule of law, predictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing the exceptions of the citizen from public authorities. This was also considered. Now, my lord, my humble understanding I am placing before your lordship, my lord, when my transfer order was kept in abeyance, my lord, I was allowed to stay for a particular period. When the authority considered my station at Kerala, my lord, after 5 years, my lord, there was also certain elements which was within, my lord, the policy. Now, my lord, this sudden meander, my lord, in the decision-making process which affects my transfer order, my lord, it is a conscious silence. Such silence, my lord, creates a path of predictability because it does not define any destination. It does not take us anywhere, my lord. And that is why the presence of malafide, my lord, ill-intended. Because, my lord, in this curial combat, my journey under fight or struggle, my lord, against the authority, against the unreasonableness in action, which, my lord, created a cloud, which, my lord, enveloped the mind, my lord, of the authority. And as such, it is a mysterious. The principles of certainty, my lord, is a command of law. That is why I am placing, my lord, with confidence, but with humility.
Yes, this was taking into consideration the rules.
Rules.
1961 rules.
Yes, 61 rules, my lord, the 2014, it is presumed that while my lord, government has made this policy, it takes note of the 61 rules.
No, here in this case that you are relying upon.
Yes.
The court was examining the authorities' exercise of discretion in the keeping in background the provisions contained in a 1961 rules, which required 25% of the aggregate posts to be filled up by direct recruits.
The decision
there was a rule.
Here, my lord, is a policy.
Here is a guideline.
Now, my lord, question is whether guideline is required to be followed. The answer has been given by the Supreme Court that in
transfer guideline for transfer.
No, my lord, question is the guideline. First of all, my lord, the basic fundamentals subject to correction, which your lordships have, my lord, maintained a consistency that every guidelines, my lord, ingrained in the policy, my lord, it is an executive instruction. Such guidelines, even if it is a transfer or any matter, my lord, the fundamental principle is that it is an administrative policy. Now the question is whether these guidelines are required to be followed or it binds the parties. Now, my lord,
you must have come across several judgments. Guidelines is one thing and transfer guidelines is another thing.
My lord, I am sorry, my lord.
Transfer guidelines, there are innumerable judgments which have dealt with.
My lord, question is
what is the enforceability and how much a person can claim as a matter of right from a guideline?
Yes, my lord.
That has been examined by the apex court.
May I, my lord, with deepest humility, try to answer my lord's query, my lord, which is in the nature of a comment. I am duty bound. My lord, otherwise, at the end of the day, executive makes a policy without any ramification is a teasing illusion. Now the court is confronted with a case, it's a dispute essentially between a citizen and the government, be it a transfer, be it a service. Now, my lord, I could not find any decision, that is my incompleteness, that the B.M. Minhas law, my lord, 84 Supreme Court, paragraph 23.
Yes, Minhas judgment, you tell us.
Paragraph 23.
Yes.
That even if it is an executive instruction, we are required to follow. Now, my lord, the question is that whether such distinguishable features have been, my lord, reflected in the reasoning assigned by the Supreme Court any of the service matters. Now, my lord, with deepest humility, my answer is, my lord, that the transfer policy is a conscious choice of the government. Now, it is like a poster, my lord. The government must, my lord, the action must be confined, my lord, so far as the confined and the action must be resorted to the command, my lord, reflected from the policy dated 28 March 2014. If, my lord, at the end of the day, if my learned esteemed friend appearing for the central government says that, yes, we have made a policy, but without ramification and without there being any compulsion to follow it, because, my lord, then, my lord, it takes us nowhere.
If they say so.
If they say so. Now, my lord, question, if that is not the utterance in the court, then whether I am entitled, I put this question to myself, to persuade your lordship's judicial conscience by saying that there must be some guideline. There must be some reference, because in law, everything is with reference to the context. As a lady Miller, my child, my ailing parents, my husband, whether these are Miller a consideration which a society or role model employer being a state Miller will consider.
Yes. Show us what do you want to show. Why this shield cover
PM
business? What is it?
As per instruction.
Huh?
As per
Department,
as per
confidence.
instruction of the department, this is confidential.
What is so confidential in a transfer?
And last judgment, Millard, I would, Millard, I resist, could not resist my temptation, Millard. That is my understanding of law, subject to what my lords will say. And Millard, only disturbance, Millard, I apologize. Millard, 23, 1983, 4 SCC, Millard. The next question that arises for consideration is whether the appointment of the respondent number 4 as director respondent number 1 is illegal because of the non-compliance with bylaw. Bylaw does not require that before appointment, the vacancy in the post of a director should be suitably publicized. In the instant case, it is it is admitted on both sides that no publicity whatsoever was given in respect of the vacancy. The contentions of Sri Garg, however, is that the bylaws having no force of statute, non-compliance with its requirement cannot in any way affect the appointment of the respondent number 4 as director of the respondent number 1. Mr. Tarkunde, however, contended that assuming that bylaw is not salutary, even so, respondent number 1 was bound to comply it. Millard, International Airport, R.D. Sethi, Millard was relied. It is well settled that the rule of administrative law that an executive authority must be rigorous, held to be the standards by which it professes its action to be judged by, and it must not scrupulously observe those standards on pain of invalidation of an act in violation of them. The rule was enunciated by Mr. Justice Frankfurter, which says an executive agency must be rigorously held to be standard by which it professes its action to be judged. Accordingly, if dismissal from employment is based on requirements that bind such agencies, that procedure must be scrupulously observed. In view of the pronouncement, I am skipping, Millard, that the pronouncement of this court on the point, it must be held to be obligatory on the part of the respondent to follow the bylaws. If the bylaws have been framed for the conduct of its affairs to avoid arbitrariness, the respondent cannot therefore escape the liability for not following the procedure prescribed by the law. So, Millard, these bylaws were, this policy was framed, Millard, for the principle enunciated by the Honorable Supreme Court. This is Millard B.M. Minha's case by versus Indian Statistical Institute.
Reply you filed by a supplementary affidavit.
They have filed supplement. They have filed.
Who have filed?
Yes, today. এই কোথায় গেল? ও ও এটাই তো না? বললো বলে তো রিজনিংটা কোথায় দিলাম? ওইটা দেখালাম না, ওইটাই পেয়েছে, ওটা কিছু বলেন নাই। Second transfer. The four terms. The terms are even remotely. এই জায়গাটা দেখো, এই জায়গাটা এই গ্রাউন্ডটা কিন্তু আজকে চলে যায় না। No, Minas. Yes, Milord. Minas, Milord.
You are reading from that only.
Paragraph 23, Minas. 83. The book is with me only. I'm sorry, Milord. I apologize.
No, all right.
And Milord, this is Milord. And 83, 4 SCC, page 582. Now, Milord, this judgment which I wish to rely. Now, Milord, first of all, there is the absence of requirement, Milord. The
4 SCC.
83, 4 SCC, 582, paragraph 23. 582.
Paragraph
23. Milord, the executive instructions are required to be followed. Now, Milord, the element of requirement, I do not know, Milord, what my learned friend has, Milord. Because this was.
See, it cannot be disclosed because it is dealing with the personal life of 50 people. Not just like that.
But if the court relies on this, Milord, because this was not on record.
Cannot there, you have not made them as parties. You could have had the option. Specific cases that 50% have been allowed,
and they have said, Milord, that we have considered the case.
We have not made them a party, therefore they have given us. Even if we do not consider this, of course we consider what is your case, but this shows a very.
Now, Milord, the requirement is also absent. Subjective satisfaction with regard to so far my case is concerned. The objectivity of the objective. Yes, number one. Number two, Milord. Number two, Milord, in all cases, Milord, that what is the definition of, Milord, the bona fide exercise of power by an authority, Milord?
Issues don't arise here. Guideline for transfer, the law is.
No, Milord, question is, Milord.
For transfer guidelines, the Supreme Court has passed so many orders.
Milord, I request your Lordship, Milord. I know, Milord, it's an Herculean task, onerous duty, Milord.
See the judgment. What it says about a guideline regarding transfer, how it is to be followed, and what is the right conferred on the individual who has been transferred. General propositions cannot be denied what you have given. Executive instructions are required
Milord,
to be observed.
I said, Milord, with my
so if this exercise is allowed, then every transfer will travel in court for years.
Milord, since your Lordships have given enough indulgence to the parties, Milord, all the times, Milord, 92 1 SCC, it is my incompleteness, Milord, I could not look into it, so that I can make.
There are many other such judgments.
No, Milord,
something
only one judgment. This is because these are sheet anchor, Milord, so far he is concerned.
No, he has not said it.
He has
we are saying it on our own.
I tell your Lordship, Milord, if your Lordship, Milord, gives me, Milord, 2 hours time, Milord,
not required.
Because, Milord, because these
we have heard everything that you have to say.
Now, Milord,
we'll consider
whether the position of law.
See, if we have understood correctly, what you are saying is there is an executive guideline. It is as good as an instruction. It has to be scrupulously followed by the authority. Authority cannot say that we have issued a guideline, still we will do whatever we want. They have not given
Even the
any reason
requirements have
why
been-
50 people who are senior to me have been retained. I have been asked.
Even if Millard, the authority is not, if the authorities are not willing to disclose the reasons,
Yes.
Millard, or elucidated, the question, Millard, that the other four
Are
clause
they
four
required to? The first question is that in every and then every annual general transfer at the end of the year will be required to be scrutinized by the court to see whether everybody has been
Millard,
done.
there is an absence of a
So
general
this-
policy of transfer because it says, Millard, there are exceptions to be Millard followed.
We'll consider, don't worry. We have seen.
But I am vehemently opposing the contention. She is in Kolkata more than 7 years,
8 years.
almost 8 years.
He is 8 years.
Doing that, and Shillong is not difficult for her because this is the administrative.
You are
part.
considering a difficulty.
No, I am not considering.
Then why are you saying not difficult?
No, this is for
Transfer can be, it's a liability, it can come with difficulty.
Hey,
The
this
point
very
is the
important.
guideline, whether you have observed the guideline or not, that is the only thing. They say you have not observed. This they could have been compelled to give you if you had made them a party. This contains sensitive information, medical information regarding so many people. It can't be made public. Perhaps that is why they have tried to give it in a sealed copy. This is gives a very
Millard, laying aside for a second, Millard, the
Yes.
other grounds, Millard,
Yes.
the in the policy, Millard, as as a lady candidate, Millard, or the other, my husband, my children, my ailing parents.
yes. Heard the parties.
I placed it, Millard. It is to be followed, Millard, by all. So it is
Yes.
mandatory.
Where is the
So today, if they come with a plea,
will be a very long
I'm extremely grateful, Millard, for your lordships.
heard the parties put up under the heading for फाइल अभी भेज देना लंच में ही फाइल भेज दो Also give this. Thanks. Thanks up. Correct. When you consider, must be considered. Transfer guideline. Supreme Court has said
Number 7.
does not.
But I am not the petitioner.
Sorry.
But in this matter, my lord, I am praying for 2 weeks adjournment to complete service, my lord.
We'll see what is the issue first. Argue on.
But my OA was dismissed,
Yes.
my lord, prior to condoning the delay.
Yes.
Delay was because the petition was pending before this honorable court.
Let us
I filed the petition before this honorable court and subsequently.
let us go through the.
That's it.
Yes, what is wrong with the order?
My lord, condonation of delay has not been, my lord, allowed. So unless the application for condonation of delay is allowed, my lord, OA application cannot be taken up. My lord, firstly, when the matter was taken up by the learned tribunal, it was directed that the reply and rejoinder will be filed in respect of the condonation of delay application, my lord. And that was done, and the matter was fixed for application for considering the condonation of delay, my lord. So unless the condonation of delay is allowed, my lord, the OA application cannot be looked into. But my condonation of delay application has been dismissed. So at that time, my lord, I can prefer an appeal for condoning the delay, my lord. But the OA application at the same time was dismissed. And the reason for condoning, my lord, dismissal of condonation of delay application, that the matter was pending before High Court, my lord. There was no laches on behalf of the petitioner. I filed the petition before Honorable Court, but unfortunately the cause title was wrong. It was written versus State of West Bengal instead of Union of India. And my lord, matter was dismissed. Thereafter, it cannot be restored because of the wrong cause title. I approached several courts, my lord, but no court was in a position to take up the application. In such situation, I decided to file another application, my lord. That was taken up. And at the last stage, my lord, there are several occasions the matter was taken up. At the last occasion, it was said that the matter should be taken up by the tribunal. And the matter was sent to the tribunal. So, my lord, this is the reason for delay, condonation of delay. So unless that delay application is allowed, my lord, OA application cannot be taken up.
So the first writ petition was not restored.
No, my lord, that is still pending on the basis of wrong cause title. That was versus State of West Bengal, and it should be versus Union of India. So different cause title and different petition, my lord. The law of res judicata would not be applicable in that case.
So what prompted you to file the second writ petition?
Well, the same grievance, compassionate appointment, my lord.
Why did you stop at 2? Why didn't you file a third writ petition?
My lord, I was of the opinion that, my lord, in several cases, High Court has, my lord, adjudicated those matters in which those matters which should have been filed before the tribunal, because alternative remedy is not the absolute bar, my lord. So I tried, my lord, as an advocate, I filed the petition and tried my level best to establish before the court, and that several occasions matter was taken up. It was not, my lord, argued on the maintainability point. At the last occasion, it was said by the Honorable Justice Lapita Banerjee that the matter will be heard by the and my lord, so far the judgment of
what is the last order passed in the second writ petition? Date of the last order passed?
My lord, I'm coming. Two 2023, 3rd October 2023.
3/10/23. Is it the correct date?
Lord, I'm showing it. Because my lord, the matter was supposed to be listed on 18th, so I am not properly prepared.
No, it is there in the order, sir. What do you mean not prepared?
I'm just
come to page 4 of the order. For want of jurisdiction was dismissed by the High Court on 3/10/23 for want of jurisdiction.
Yes, my lord. That is the date, my lord.
What is there to prepare? We have seen it in 2 minutes. All right, take down. Our learned counsel for the delay. The order is both on merit as well as delay.
Unless the delay is my lord,
Sorry.
allowed, my lord,
All
the
right.
merit cannot be entered.
That we have said. That we have your submission, we have noted.
Jayanto Mitra. Jayanto Mitra.
Number 8.
Please, Your Lordships, I am for the petitioner. Lord, before I commence the submissions, Your Lordships always peruse the order and the synopsis. And I believe, my lord, half of my submissions are what is contained in the synopsis. Just as, my lord, the cat has gone into a matter of policy, not a transfer order per se. There was no transfer order that was under challenge. A transfer policy was under challenge. The cat has issued a stay on the entire transfer policy. That is, in short, the matter, my lord. I filed a vacating application. The cat doesn't look at the merits of the vacating application. It says, oh, you've not filed a reply. Therefore, I will not vacate the injunction. That is, in short, my writ petition. While my lords are perusing the impugned order, may I kindly, my lord, implore your lordships to see the second last paragraph of the second page. That is the reasoning.
Till then, they have not filed the. The court said, tribunal said that 17. Instead of doing that, come here. Earlier also, the earlier policy was.
Dear my lord, I am not before my lords seeking quashing of the proceedings before the cat. I have filed an application on maintainability. The Honorable Cat wanted me to file a reply.
What happened on 17th?
On the 17th, my lord, the matter could not be taken up due to paucity of time. I had filed my reply by then because I was given a chance.
When is the next date?
My lord, this 17th. Because again, and may I
go there?
My lord, this matter has been.
Sir, for the respondents.
Answering is.
Whoever it is, they will all appear there.
My lord, the only difficulty, may I kindly place, my lord, two orders. This matter has been getting pushed. There is litigation
See,
going
for
on.
the last 3 months, if on 17th, if you had not approached this High Court, maybe something would have happened. Why you have come here? On 4th, the court says we have already fixed it on 17th. It will be considered, and you rush to the High Court.
No, my lord.
And for 3 months it stayed because you are pending here.
May I kindly indicate that matter is
Go there.
17th of June. 17th of June, the matter gets transferred to another
17th
date.
April, it was fixed.
Yes, my lord.
4th April, the tribunal was hearing your vacating petition. Tribunal said, why have you not filed your reply yet? You said, we have not filed it, we have filed a vacating. Tribunal said, all right, it is fixed on 17th, we will consider. You rush to the High Court.
No, my lord. May I kindly, my lord, indicate? Your lordship, because it's fallen from your lordship.
No, it is apparent from the order sheet.
No, my lord. May I kindly show the order sheets?
The order that is before us.
Yes.
Just read the second page, second paragraph. Last but second paragraph.
The impugned order, your lordship.
We are prima facie of the considered opinion that as per the respondent, OA, this transfer policy has no relation with the present members. Today is 4/4/25, but no reply has been filed till date. OA has been directed to be listed on 17/4. So there is no urgency to vacate the interim order now. Since 28/2 it was continuing and it should be vacated for 10 days. Why didn't you appear there?
Lordship, I did. May I kindly, my lord?
Where is the requirement of coming to the High Court?
I'll tell your lordship.
This order shows that there was no scope for coming to the High Court.
My lords would kindly give me an audience of a minute. May I kindly try to impress your lordships as to why I have come before your lordships. Your lordship would kindly see what happens on 17th April, page 163.
That's not part of the record.
Page 163, my lord. Annexure P5. That is what happens on 17th April.
163.
Yes, my lord. I am not even showing the subsequent orders where again a single bench takes up this matter. It says, I can't hear this. Let it be put up before another single bench. Another single bench takes up the order. It says, no, this involves a substantial question of law. Let it be put up before the division bench. Which is why, my lord, I use the term litigation football. That is exactly what is going on. And my lord,
when did you file your reply?
I filed my reply on the 17th of April, my lord.
Where have you said that?
My lord, I have said that in my pleadings. It has not been recorded in any order. I have filed my reply along with the MA for MA for maintainability. I have filed it on the 17th of April.
17th April. Have they already? It has been affidavits have been exchanged.
Yes, my lord. Yes, my lord. Thereafter, the matter came up for
hearing. They have filed a rejoinder also.
They have filed a rejoinder. Thereafter, the matter came
17
up.
June is, you said, what is the next date?
17th July, my lord. My lord, because twice thereafter this matter came up before two different single benches. One single judge says, I could not hear.
Final order has been passed on the vacating application.
This is the final order on the vacating application. My lord, vacating application has been disposed of, which is why, my lord, I am aggrieved. Vacating application has been disposed of without even considering the merits, without seeing that there is no transfer order that has been challenged. It's only a transfer policy, my lord.
And this policy, the earlier policy was also stayed by the Mumbai bench.
No, my lord, that is what is the misrepresentation. There, if your lordship sees the OA, they themselves say that transfer orders emanating from a transfer policy was challenged, which is now, after a round of litigations, it went up right to the Honorable Supreme Court. Now it's before your lordship. Two transfer orders from the erstwhile transfer policy are before your lordship. Transfer policy of 2022. Their submission is that because two transfer orders from an erstwhile transfer policy are pending before this Honorable Court, no subsequent transfer policy can be given effect to. That is why, my lord,
I am going to enter into the merits.
Your lordship, I would not invite your lordships to enter into the merits. I would not invite your lordships, but your lordships would kindly see prima facie what is happening. And the effect, my lord, the AGT has not happened. On medical grounds, there have been no transfers. On compassionate grounds, there have been no transfers.
17 July.
July, my lord.
All right. You are representing all respondents. Who is two?
The pro forma respondent, Union of India, my lord. But I have served. I have to copy.
You have served on respondent number one?
Lordship.
You can go in favor of first respondent.
Today, my lord, I am not agitating the merits.
We have understood your difficulty. That's why we are trying to see there is two options. One is you can serve, they can come, it will get delayed.
Oh, yes.
The other is that we'll allow you to file up MA afresh, you serve on them, and we'll direct on 17th, the tribunal should consider on merits.
Your lordship, please, I have filed it. I'll tell you, your lordship, what is happening on the 17th, what is coming up on the 17th. I filed another MA on the ground of maintainability. The earlier MA, which is now before your lordships, that was on the ground of that was to vacate the interim stay, because on the first day the interim stay.
There also you were raising the issue of maintainability that they cannot challenge it. So essentially it was one and the same thing. So therefore, if this MA suffices, whatever is pending, let that be taken up.
Would Millards kindly?
What is that MA number which is now pending?
325, your lordships. 325.
325 of 25.
2025.
So if that is decided, then the issue will be over.
My lord would kindly consider this one prayer. Your lords would kindly consider at least directing that the stay should be. I am not on merits, but at least the stay should be lifted, my lord, because otherwise all the transfers are in jeopardy. No medical transfers are happening.
Hardly any time now. Again, you are in the same situation. We are already, it is 10th. So next Tuesday it is to be, or next Thursday it is to be taken up. What is the big deal?
My lord, if it's not taken up for whatever reason, your lordships may direct the tribunal to take it up. If it is not taken up, your lordships would keep this matter pending.
It's already filed MA number 325. MA 325, if it is decided, then your issue is over.
Then it is. Then it is, my lord.
On the MA, have they filed any reply?
They have, my lord.
They have already filed.
Yes. Even those pleadings are.
You can take your submission on record to this effect, and you don't have to file any rejoinder there too.
I have filed.
That is also done. All right.
I
The petitioner.
filed.
Item number 9.
And I am for the petitioner, my lord. I am a
For 1 month salary, you are before the before us.
no, my lord.
Then
The tribunal did not consider that the termination notice.
Where is the order of termination?
That is at page number 32. That is, my lord, dated 27th April 2012 and directed to discontinue from 2nd of May 2012.
Yes.
Without assigning any reason. My case was that kindly turns the next page, my lord, page 33.
Dismissed in default. It is dismissed in default.
Dismissed, once it was dismissed, the can code.
When it was restored? Has it been restored? No.
First, I have to restore, my lord, I have to if I
Yes, on merits, let us see. 33, what is it?
page 33, my lord. On 21st of February 2012,
Yes.
Deputy Joint Secretary directed the district collector to send name of fresh personnel. And what he has said, LA works on the second line last, LA works pertaining to various projects in his district to which no approval was given during last 6 months with immediate effect, and to send name of fresh personnel. But here the joint secretary told that where last 6 months where there is no person, no appointment. But in my case, I have been appointed till kindly turn to page 40, my lord. I have been reinstated as, from January 2012 to June 2012. In this case, I have been appointed, my engagement has been continued till June 2012, and in nowhere my lord can find that this letter of page 33 where no approval was given during last 6 months with immediate effect. I have been approved during last 6 months. There is no reason assigned. And first of all, letter dated 24th April, notice dated 24th April, with effect from 2nd of May. It's within 1 month, my lord.
That the tribunal has said that they will give you 1 month.
1 month, but natural justice must be.
What natural justice? You are a contractual engagement.
But
you have been
kindly,
engaged for this work
kindly,
for 6
kindly, my
months.
lord, comes to my agreement at page 34.
Yes.
Kindly page 36, my lord, clause number 9. They have also relied in their opposition that clause number 9. Notwithstanding anything contained, this agreement may be terminated by the district magistrate and collector giving to Sri Madan Mohan, that is the petitioner, either 1 month.
Clause 9 is the only thing.
And I will say, my lord, clause 10.
Yes.
Clause 10, my lord, kindly see. The district collector can terminate my engagement without any notice for these reasons.
Yes.
Here, my lord, no reasons has been shown.
Yes.
Without any
What
reasons.
is your date of engagement?
I have been engaged since 2006. Thereafter, I have annexed my appointment letter of 2006 at page number 38, my lord.
Since 2006?
2006, I have been continuing this work.
Where is that?
Page 38, my lord. Page 38. Since 2006. My first appointment letter, my lord. Without drawing up any proceedings.
Proceeding?
At least.
Then we have to learn something.
My lord. My lord.
Then we have to learn something today.
My lord.
A contractual employee engaged for 6 months and he has to be
subject
to a proceedings.
I am continuing since 2006,
Very good,
my lord. And my
maybe
lord,
since 2001. So
and
proceeding is required.
Maybe, my lord, agreement Agreement, my lord, kindly again turns to page 34 again, my lord.
Yes, we have seen that.
No, page 2, clause 2, my lord.
Yes.
Clause 2, my lord. The engagement of Sri Madan Mohan Nath shall be for a period of 6 months from the date of his joining. Kindly cease, my lord, from
And all the
joining
persons-
in the project
All these
or
persons-
completion of the project work, which is
all these
earlier.
persons who are in the order
No,
27
only
for
one has come before
27 for 2012, they have all been discontinued.
my lord. They all have been discontinued.
Thank
And my lord, kindly see once, my lord, agreement page 34, clause 2, my lord.
Yes, we have seen it.
Clause till the end of the project.
All right.
And in my reply, I have shown that the project of Newtown
Heard learned counsel for the petition.
My lord,
Yes.
my lord, yes, my lord, this writ petition, my lord.
Which petition?
My lord, 10.
Number 10.
I relied on a rule, my lord, which was framed by the government, my lord, 1965. I was not very much certain and sure, my lord, that whether any subsequent rule has been framed. My lord, I am told, my lord, just now by my learned friend, your lordships were kind enough to direct my learned friend to take instruction. New rule has come. I need to consider this, my lord.
Your lordship, a submission was made. May I take 2 minutes of your lordship's time?
Yes,
A
please
submission
remind us. We don't have that sharp mind.
was made by my learned friend, senior friend, that the advertisement was passed against the rules of 65, your lordship. Though the pleading was not even taken before the learned tribunal, neither was it taken in this writ petition anywhere, your lordship. After participating, after being rejected, his candidature being rejected, at this stage a submission was made that the advertisement was against the 65 rules, your lordship. Your lordship, to that effect, your lordship was pleased to direct us to take instructions. In 2012, by way of a notification, 1st August 2012, the West Bengal Health Recruitment Board was empowered to make all the decisions and the appointment processes for direct recruitment in the health department, your lordship.
This is for recruitment to which post?
Your lordship, kindly see, this petition is for the post of
Inspector of Drug.
Inspector of Drugs.
Your lordship will kindly see the notification, paragraph 1.
Let him consider. Give him a
I shall give my learned senior friend a copy of
pursuant to the, here, take down, pursuant to the last.
বিনি আমি করে দিয়ে দিচ্ছি এই জেরক্স করে দিন
Number 11.
My lord, 11 is my application, my lord. In this matter, my lord, I assailed a transfer order from in the tribunal. The tribunal, my lord, rejected my application. My lord, what failed from your lordship, a query failed from your lordship that whether he has joined or not. My lord, he joined the post, the transferred post. My lord, thereafter a medical board was constituted. My lord, I have instruction that, my lord, he had gone to that medical board. The, my lord, report of the medical board is awaiting. My lord, kindly gives us, my lord, 2 weeks time. By that time, the medical report will be available to us, my lord. That is necessary for the adjudication of this case, my lord.
What is the relevance of the medical board?
Because, my lord, my transfer, my lord, I had, my lord, assailed the transfer on several grounds. One of the grounds was medical.
As played by, there is no interim order.
No interim order.
Number 12.
Reply ready. Reply ready.
My lord, I'm appearing for the petitioner, my lord. I'm praying for some extension to affirm the reply, my lord. It's not ready.
How much time you?
2 weeks, my lord.
As prayed by land council for the
Number 13.
Your lordship, I appear on the state in this matter, your lordship. So the direction to file affidavit in reply, but no copy has been served. Like,
what has not been served?
My
reply.
lord, affidavit in opposition was my lord served. But I prayed earlier, my lord, to file reply. My client is, my lord, he is ill. So that's why, my lord, I'm praying some sort of time, my lord, 1 or 2 weeks time to, my lord, file.
Any interim order?
No.
Yes, time for filing reply is extended.
হ্যাঁ কবে কবে না টুইক্স কবে ডেট কবে ডেট নেই
Number 14.
May I please, your lords? My lord, they gave us the, my lord, opposition. We have filed a reply. My lord, your lordship may recall that matter, a doctor who has been working but not getting the normal salary. Lord, this is a case like, my lord, the wolf and the lamb. Very difficult to convince the wolf that the lamb is innocent. Since 2011, there is no dispute. I am in regular service. But, my lord, they are paying me half salary without any incremental benefits. And one thing, my lord, earlier I, my lord, failed to draw your lordship's attention. When earlier, my lord, the petitioner came to this honorable court, the honorable High Court, my lord, was pleased to pass an order. Though, my lord, it was delegated to the tribunal. Kindly look at page 71. The director issue is, my lord, is still, the lease is same. The director of health is directed to submit a detailed calculation on the entitlement of the petitioner, which is claimed in the instant application. According to the page 71, my lord. According to the petitioner, the colleagues who stand on the same pedestal, that of the petitioner, are getting higher amount per month than that of the petitioner. Let this matter be listed on December 22nd, 2021 to enable this authority to produce the documents. Then, my lord, next page. Despite the direction passed on 17 December upon the Director of Health Services to submit a detailed calculation on the entitlement of the petitioner, which he claimed in the instant writ petition, and pertaining to the merit of the case submitted by Mr. Topan, my learned senior friend, learned advocate state, which is received from the said director. There is no hesitation in our mind that the same is not in the tune with the direction on 17 December. Let the same be kept with the record. However, the hearing of the parties, we feel that we are not an factual issues, more particularly on the unauthorized absence, such and such. So, my lord, they did never file any, my lord, opposition or my lord, report anything. Then, my lord, with the change of determination, the matter was delegated to the again to the director, and my lord, director was directed to, the order was the director shall decide the, my lord, claim of the petitioner about the incremental benefits and, my lord, regarding arrears like that. But the director, your lordship, earlier I placed, constituted a committee Enquiry committee. In enquiry committee, my lord, on the spot, I was asked to, I was given a, my lord, questionnaire. On the last occasion, lordship put me the question that why did you not produce the document in support of your contention? Because I kindly mark the page 80 at the top, health services, 16th October 2023. When, my lord, I appeared, they gave the questionnaire and said that you fill up and deposit, submit. My lord, your lordship on the last occasion putting me the question about the leave, kindly look at page 82. Page 82. This in the report, subsequently now they have, my lord, annexed with the opposition. Opposition, as per the acquittance rule, my lord, kindly page 82. As per the acquittance rule, salary of Dr. Fazlul Islam for the period from August 9 to October 9 had been drawn by your office from the government exchange from time to time. But later on, the salary for about 3 months was ultimately deposited to SBI, Domkol, though RTA Chalan, due to the non-receiving of the salary. Please state the reasons for non-receiving of salary for your end, from your end for the said period. Due to the less amount of salary drawn by the DO and also as per advice of the learned advocate, the case was under judgment on the honorable set. So, my lord, they were paying me 20,000 or 30,000. I was entitled to get a more than, my lord, 1,40,000. That's why I, my lord, advise that you should not take that paltry amount. That has not been paid. Then, my lord, do you have anything more to add on this case issues in your defense? State briefly the supporting documents. On the spot, my lord, I was not. Please, release of my arrears salary, incremental benefits along with the update service book. The name is shown as Dr. Fazlul Islam and marked as absent is fully wrong and intentionally done. The handwriting is not the same like other doctors. My lord, show, my lord, this is the situation regarding unauthorized absence or like that. So, my lord, that aspect has in the report, my lord, that has not been at all considered. And my lord, kindly see the other questionnaires. I said that it was I did not receive any such letters from the page, my lord, 83. They are saying that we have issued letters, so-called such and such. The answer against those unauthorized letters addressed to CMOH Murshidabad regarding my absence is not correct. I did not receive any such letters from BMOH Islampur. Such type of letters were totally manufactured by the BMOH Kartikpal and others, Islampur such and such. So, my lord, regarding, my lord, what now they have stated in the, my lord, after getting the report, my lord, I have filed the, my lord, reply. My lord, may I place the reply slowly? And your lordship kindly mark one important thing. Page 27 of their opposition. Thereafter, reply was received with regard documents such and such, except the attendance registers for the period from 2009 to 2011. This is the, my lord, crux and vital part of the case that they have not produced. Before the inquiry committee, attendance register was not produced. My lord, may I place the, my lord, my reply? My lord, when a man is working regular service, day and night he is giving the service, he is getting half salary without any incremental. Maybe I am an offender. I committed wrong. But that is, my lord, closed chapter. And in, my lord, on 4 occasions, they did never file any evidence of opposition, neither in the Honorable High Court nor before the learned tribunal. And another thing, my lord, page 28 of their opposition, on the when, my lord, on the spot inquiry, I answered the questionnaire. Next date, I was called. As there were certain legal problems, my lord, so the petitioner went along with his learned advocate. Kindly look at page 28. In at the time, may I read out, my lord, page 28, last 2 paragraphs. This time, all the concerned persons are present accordingly before the inquiry committee on the scheduled date, time, and except Dr. who came before the inquiry committee later on that day along with his legal aid without taking any prior permission, intimate to the authority. In response to the members of the inquiry committee suggested to Dr. Islam to either remain present or face the inquiry process on his own without his advocate, or to fetch permission from the DHS West Bengal to allow his advocate to be present beside him in the inquiry room. As a result, he started to urge with the members inquiry committee and left the inquiry process together along with his advocate. While leaving the inquiry, he threatened to take, well, this is not correct. He said that in the accepting High Court, I shall get no justice. The inquiry committee had continued the process. So I went along with a lawyer. I did not commit any wrong, my lord. My lord, that allegation I have dealt in paragraph page 17 of my reply at paragraph B. From the inquiry report, your lordship, can you look at paragraph B? From the inquiry report, it would appear that on 16/10/2023, he was allowed to participate and appear before the inquiry committee. But when another date was fixed for appearance on December 7, 2023, the petitioner, along with his learned advocate, Mr. Subir Sabud, appeared before the inquiry committee. Mr. Sabud is my junior. Before the inquiry committee to place his case properly. Unfortunately, the inquiry committee did not allow the petitioner and his learned advocate to place his statements and arguments on the plea that without the permission of the director, the respondent number 2 advocate would not allow to place the case of the petitioner. The members of the committee did not allow either the petitioner or his advocate to place his case on December 7, 2023. The petitioner sought to place his defense with documentary evidence and sought justice. The members of the committee did not allow the petitioner to place his case. In the said report, the members of the committee alleged that the petitioner left the inquiry room with threats to take the matter to the court again. Such allegations are absolutely untrue, inasmuch the petitioner sought to place his case through his advocate, as the petitioner is not an expert on legal matters. So he took the help of an advocate. Unfortunately, the same was not allowed. The petitioner politely left the committee room, only saying, except court, he would get no justice. The entire decision-making process is thus vitiated with malafide, prejudice, and malad bias. What I am putting the question to myself: what a doctor can do? He is not a legal expert. They are
why there is a direction for recovery of more than 13 lakh rupees?
Can you see page 29 of my affidavit
Of your
opposition? The findings of the inquiry committee.
No, the findings are there at page 85 of the brief. It is different or the same? Page 85. It starts from page 87. This is the reasoned order.
Yes, reasoned order.
Passed in compliance of the writ petition, 19/6/23 order. You are referring to this?
Yes.
Yes.
Page 29 or
29 of opposition.
Report was not there. That's why we have added the inquiry entire report of the inquiry committee. That was the 2013 by further quarterly. On the next month, again serial number 1, Dr. Basir Staff was absent for 4 months. And in another, after he on past February 2013, and impossible 30th February 2013 he signed. But I do not find anybody last 50 years or more than 45 years in the profession. That any day, 30th February of a particular year.
Why you are saying only 50 years?
At least my knowledge.
Impossible. Can't be.
At least my knowledge. I may be poor because I have no experience. An impossible calendar date.
That is
high.
That is.
Only after 4 years, 29 February.
That is there. Maybe my lord, I am frankly,
What have you done?
But as soon as this amount is adjusted, he will get all incremental benefits and pay fixation because we want to recover the amount he has.
So this report, which you have just now placed, he has challenged this report.
It was never given. This is for the first time it has been annexed. Oh, that is the report, that is the reasoned order. The alleged reasoned order was challenged.
I see page 33.
30?
33. What are the documents considered?
No. What we are saying is, this is a finding recorded by you
Yeah.
in an inquiry committee.
Committee.
This was served on him.
Yeah. And
When?
that was.
No, never it was served. Reasoned order, but inquiry report was, this is for the first time. In reply, the opposition they have given, in reply I have dealt with.
So now this, unless this is assailed by him, nothing can be done. This has to be assailed. We don't know. This is an inquiry report. This is an inquiry report.
Yes, inquiry report.
So after this, did the disciplinary authority take any action on this inquiry report?
On the issue of the inquiry report, director passed an order.
Where is that order?
That order is, my lord, at as page 87 onwards. That I have annexed. That was the challenge.
It cannot be, sir. It cannot be. What you are showing at page 87 is of April 24. And this is of July 24. 17/7/24. If we are reading correctly.
My lord, that was challenged.
17th.
My lord,
When you have received this? When you have received this?
the inquiry report or earlier order?
A reason order.
Reasoned order, my lord, I received, my lord, that is day after date. Kindly look at the date.
Where you have
April,
mentioned?
page 90, April 15, 2024. After getting this, my lord, we questioned. When it, my lord, as per Honorable Court's order, we filed a representation. That was directed to be considered. At the time of consideration, my lord, the inquiry committee was constituted and any report has been, now they have annexed with
This inquiry committee was constituted pursuant to the court's order.
No. That's why I have taken a point, my lord. This is a quorum non judice.
Page 27.
Order passed considering the report.
Reason order has been challenged. Sat on the delinquent. Versus Karnataka. Was the inquiry report served on him?
No. For the first time in opposition, they have annexed.
Then where have you said in your OA that this order, reasoned order?
That one mistakenly I did not say.
Then that is not your case. Don't make a statement of fact which is not on the record, please. Please, we don't appreciate that. You are relying on a reasoned order which has taken note of the inquiry report. You don't say that inquiry report was not served. Then how a counsel can say that it was not served? Then it was served.
Now
You have challenged the reasoned order. The reasoned order refers to this inquiry report.
No, but in the
what no?
In
What
the
do you mean no? Come to page 89. What is no?
89, my lord.
Yes.
Now it is
evident from the report submitted by the committee.
But
no.
Yes, your lordship. No, your lordship is perfectly right.
Then,
I challenge this.
Then don't say inquiry report was not served. It was served on you.
My lord, it is evident from the report.
What is wrong with
submitted by
this
the
order
counsel-
then? Yes.
No, kindly mark, my lord, mark the word.
Nothing is to be marked. It is relying on an inquiry report. You have not stated that this has been decided without giving me a copy. That is all.
That was a mistake on my
Not
part.
a mistake. That is the hard fact which you have to carry
My lord,
till
the-
now.
The committee,
That's
my
not a
lord,
mistake.
the director decided it on the basis of the reports.
Correct. He is supposed to. That is the procedure.
Had justified.
Inquiry report
changing
is
the matter, had
submitted,
not been
copy is served on the delinquent, and order is passed. That is a settled procedure of a departmental procedure.
Let them show, my lord, any document that I was served.
They are not required to. They are not required to show. It is not your case that it was not served. By making a loud submission, it will not add any.
I am, my lord,
Your
it is
substance,
it
your
is my
such
humble-
submission is devoid of any substance.
My lord,
It is a wrong submission
my lord,
in view of the
it
records.
is my most humble submission.
Whatever it is, this is
It
not
was
your
never,
case.
sir. Anyhow, my lord,
Anyway, so why this huge amount has been required to be recovered? 13.
For the period he was absent, not performing the duties, he has drawn the salary.
What is the period? How many days it has been quantified?
Just one.
Because why we are asking you, see, please come to another document wherein you have said that it is 121 days at page 81. Please see page 81. 121 days cannot be 13,42,000.
9 months. 9 months salary will be.
23, they are saying 121.
How many days?
In 24, how it will become?
2013 absent.
No, please try to see. We are asking you because we want to see whether you can reconcile.
Yes, put up.
Page 81.
Page 29.
Page 81, sir. Please see page 81. Whether you were absent from duty for the period as stated below. This is, all of this is taken together. 121 is the last.
For the period of unauthorized absence.
Yes, then.
For the period of unauthorized absence.
No, all these are separate periods. It's not total. 121, 5.
the left hand side, yes. The dates of
So what is the infirmity in the inquiry? That is all you have to say. What is the infirmity in the inquiry? That is all you have to say. We'll hear you. We are coming back. For what? For this. Yes, what is the procedural information in the proceeding?
The proceeding, my lord, from the very inception, this honorable court was pleased to initially, my lord, the learned tribunal was pleased to direct the, my lord, the director to decide the claim of the page 60, my lord. This is the initial order. When, my lord, the dispute cropped up, we approached the honorable learned tribunal. The learned tribunal passed an order and page 60. My lord, it starts from order in view of the submission made by Mr. Mustafa and prayer.
No, now the inquiry has commenced after the division bench order. Forget all that. That is now history. That is not relevant
in
today.
the inquiry, kindly see in the what they have said, my lord, in their report. They have only, my lord, taken into account only the allegations of absence. Allegations of absence. But, my lord, no document has been produced or annexed with the, my lord. Kindly see the report, page 27, steps taken by the inquiry committee. My lord, we question the very constitution of the inquiry committee because, my lord, it was direction upon the director decide. Maybe, my lord, for the ends of justice or for better appreciation of facts, he constituted the inquiry committee. But kindly mark one thing, the whole issue is, my lord, my absence. Now, steps taken by the inquiry committee. Thereafter, a reply was received from the required documents from the BOMH Islampur, dated such and such, except the attendance register for the period from 2009 to 2011. These are the, my lord, relevant period. The inquiry committee and, my lord, most important aspect. The attendance register was never called by the, my lord, inquiry committee. So, my lord, allegations about the, my lord, there is no unimpeachable documents on behalf of the state to establish that I was absent. They have only calculated days. And kindly see, my lord, page 28. The inquiry committee, the alleged inquiry committee called different persons, but the most important authority, the district health, CM, Chief Medical Officer of Health Murshidabad, was not called. Under whose supervision I am in the service. He was not called. CMHO, Chief Medical Officer of Health Murshidabad, he was not called in the inquiry, in the inquiry committee. He is the best person to produce all the documents, attendance, everything under him. He was not called. Some persons are called, my lord, the page 28. So during inquiry committee, he failed further in Dr. Islam, Dr. Sachindranath Sarkar, Joydeep Chaudhary, BMH, block medical officer was called. But the district, the CMH, he is the head of the state. He was not called. No, district, in which I am the employee.
Which is the block.
Block people,
Under the block.
block authorities you are called, but the district authority was not called.
There is no any irregularity to call a report from BMHO, BMOHC.
From CMH, nothing was called. He was not called in the inquiry committee. Then, my lord, in 2 days I was called. First day I appeared, my lord, the questionnaire was given. I filled up the same, submitted. But in the second day, my lord, I was called, but I was not allowed to participate because I went along with a lawyer. My lord, that is as page 28, first, second, third, fourth, sixth paragraph. In response, the members of the committee suggested Dr. Islam to either remain present or face the inquiry process on his own without his advocate, or to fetch the permission from the DHS West Bengal, allow his advocate to present beside him in inquiry committee. As a result, he started to argue and left. So, my lord, he is not a legal expert, he is a doctor. And they have calculated the leave, but my lord, for assuming but without admitting that I have overdrawn rupees 13 lakhs. But since 2011, I am getting half salary without increment. If that is calculated, my area would be about 1 crore. More than. Let them, my lord, deduct my amount and regularize my incremental benefits and other benefits. That's why earlier, my lord, this honorable court directed them to submit the calculation and other. Well, as I placed, my lord, Mr. Justice, Division Bench of Justice Tendon, and that document I have shown, but they have never come forward. And in the, my lord, in no proceeding, my lord, may I place at the cost of repetition, page 71. The Director of Health Services is directed to submit a detailed calculation on the entitlement of the petitioner, which is claimed in the instant writ petition. According to the petitioner, the colleagues who are on the same pedestal, that of the petitioner, are getting higher amount per month than the petitioner. But, my lord, it was not. Then, my lord, next page, 72, paragraph 2nd. There is no hesitation in our mind that the same is not in tune with the or the direction dated September. They never, either in this honorable court or before the tribunal, they did never submit any, my lord, calculation. And one, your lordship, kindly, one thing, my lord, your lordship would take notice. See the, my lord, earlier consideration. The matter was twice considered. The second consideration, my lord, the exact replica of the earlier consideration. Kindly look at, my lord, page 68 onwards. Same story. Then, my lord, 69 bottom. Now, therefore, after careful consideration of the entire gamut of the case, the undersigned is, this is of, my lord, January 24, 2020. Now, therefore, after careful consideration of the entire gamut of this case, the undersigned is of the view that since the local authority, BMOH, Islampur, is yet to reply regarding unlawful disbursement of the salary of rupees 13 lakhs and odd, hence, at this juncture, there is no cogent reason of giving any relief to the petitioner right now. The local authority was also requested to opine regarding the entitlement of the petitioner's claim. After obtaining the reply, the BMOH, we should issue the final reasoned order. That was not done. Then, my lord, kindly see the next page, page 70. My immediate superior authority, Dr. Ramakant Majumdar. I, being the block medical officer of health, Rural Hospital, do hereby declare that, say that Dr. Bozul Islam, additional medical officer of Harampur, who was regular in service, He was not absent during his service tenure in this hospital, as has been sought and projected by the higher authority in this report, in their report. If the attendance register of the relevant period is looked into and examined, the truth would come out, and the alleged absence of Fazlul Islam as shown in the report are contrary to the records. There is no question of overdrawal as shown in the report. But this has not been, my lord, taken account. And kindly see the last, the order which they passed. My lord, exact replica of the earlier order, excepting the last two lines. Page, my lord, 89, bottom. My lord, they have repeated the same story then. Now it is evident from the report submitted by the Constituent Inquiry Committee that Dr. Islam had failed to justify his stance in the instant matter and had not been on unauthorized leave from duty on several dates. Moreover, the petitioner has also attempted to mislead the such and such. Then it is ordered that the said overdrawn amount be recovered from at the time of retirement. But I am putting the question to my why, man, at the time of retirement? Why now, not now? And my lord, then this honorable court was pleased to pass and direct the petitioner to make a representation. I made the representation. This order has been passed. Now, my lord, in reply to their opposition, my lord, may I place the reply? My lord, from paragraph 2, 3C. The core issue in the instant writ petition is the non-payment of yearly incremental benefits to the petitioner, which is the incidental of government service. Since April 2011, though the petitioner is in regular service and non-payment of arrears salary from the period from 2009 to March 2011, in spite of demand to that effect, and direction of the learned tribunal upon the Director of Health Services to consider the same. My lord, may I place, my lord, the rule? Without drawing up any proceeding or order, incremental benefit cannot be stopped. Just I am reading out, my lord. My lord, I am reading out aloud. Withholding of increments. An increment shall ordinarily be drawn as a matter of course, unless it is withheld. What documents? Let them make proper calculation, deduct.
Why are you not conducting a proceeding against him? Huh?
They wanted to proceed with the deferment relief. I asked them, since matter is pending before the Supreme Court, kindly do not.
Where is that show cause?
Show cause notice? Why?
No, show cause will not form the basis of an inquiry. There has to be a charge memo.
Charge sheet could. I've asked them do not issue the deferment
because this is pending.
Because the pending.
Oh, why?
Is there any stay? Is
No,
there any stay?
but sometimes court take exceptions.
You will wait for 10 years if the
No,
order will not taken up.
And apart from the period of absence, why are you not paying him?
We have said so in the affidavit.
Yes.
That as soon as this amount is adjusted, we will give them the incremental benefits.
That is what he is saying. Let them adjust and
Let
pay.
them deduct.
That's I have said so.
What is the problem? You can return.
When I shall return, they will let them deduct here and now. Make them proper calculation.
Yes.
Since when have you not paid him salary?
He's getting say about
Since 2011, I am getting.
You are getting salary.
Yes, but my lord, my colleagues and my other officials, they are getting, my lord, 1 lakh, about 1,90,000. I am paid only 96,000. 1 lakh is less.
As soon as this amount is adjusted.
The way you have been apparently performing duties, you are fortunate to be getting that amount.
Since
Lots
2000,
of opportunity given to return the money.
since
Lots of
2011, there,
Otherwise,
since 2011, my lord, there is no problem. Before, and my lord, no order was ever passed. My lord, as I was reading out.
How? He's saying deduct it.
Yes, but we have said so in the affidavit. But I say that until unless unnecessary absence and illegal drawing of salary is decided without perfect duty, question of payment survey cannot be decided after adjustment of the withdrawal amount or service going to be.
After adjustment means when?
Well, immediately, but as soon as the dispose of within 4 weeks, the adjustment will be made, and whatever the incremental benefits he will entitled, that will be given to him.
And proper scale of pay.
See, there are two aspects of the matter. One is that some amount has been withheld.
Yeah.
There is no proper order after a proceeding directing for withholding of this amount. You can pay that amount if you want. We are not coming in the way. But at the same time, you say you propose to conduct an inquiry against him.
Yeah.
So what do you want to do? Tell us so we can record and dispose of the matter. He is willing that if you take this money, you take it.
But if your lordship permit, dispose of the application, giving us liberty according to the adjudication made.
No, what we are saying is you take instruction. If after deduction you are willing to close the issue,
Yes.
then we will record that. If after deduction you want to proceed, we will record that. Whatever you want to do.
Yes.
But you tell us. He says that let this story be finished now.
Yes.
He doesn't want to carry this. Whatever he is entitled to now, he will get it. After hearing.
They are not getting proper my lord, feedback from the house. He committed some wrong, my lord, maybe before 2011. But after 2011, your lordship has seen twice or thrice. I said him that you go. He told me that whole night I'm on duty.
We don't know. We have not seen.
Anyhow, my lord.
We
I
don't
asked him
see.
that don't waste your time in court. Go to the hospital, do your duty. I shall take care of the case. I'm extremely grateful. But if I get 1 crore, 13 lakhs is nothing.
Let's see what they do, what they propose.
Yes.
Item number 155. Item number 155.
Excellent. But your lordship can make it part hard. Then but the next day, my lord would not be available. My lord would not be available. As your lordship, please. No difference. Great.
White House fixed at 2 p.m.
But this is Lord, that matter, Lord. My learned friend was directed to take instructions from the office of the official receiver, High Court, Calcutta. Lord, this is relating to reversion and recovery. Now recovery has been done to the tune of about rupees 70,000 from the salary of the petitioner. Now, thing is this, 1 year was erroneous promotion according to them. But I was given the responsibility to discharge the duties. Now, from 2014, I was holding the post of estate supervisor.
Yes, we had asked you to take instruction. In fact, you had said that you will be taking instruction.
This is the government order dated 9 January 2012. In pursuance of the vacancy position where the commission was given from September 2012. Position arose by now here the middle arose by head assistant, head clerk, 4 posts, duty clerk, 21 posts, accountant, 1 post, accountant clerk, 2 posts, supervisor of estate, 2 posts, and 1 division clerk, 22 posts. Total is 52. And up to 50. Now, how it comes to date 16.
Yes, why 64? How 64 is relevant?
What I am submitting is that order the vacancy position.
Can you switch on your mic?
Yes. By implementation of this order, the vacancy position, he was given promotion with effect from 1st September 2014. That vacancy position arose by reason of this order. Now, he has made out a case that he was after 8 years of serving in that post, he has been reverted. Now kindly comes to page 67. This is an order, dated 26 July 2021, the government's order. By this order, one more additional post is created by the government and the entire staff pattern of the office is changed retrospectively from 2008. Now, kindly allow me to place this order, Milord. Kindly see, Milord, this is a prayer of one Dulal Chandra Nondi. He is a staff of that office for taking suitable action regarding his due promotion to the head or assistant on the office of the official receiver, High Court, Calcutta. Milord, kindly see, then we may agree to treat the post of accountant 1 post, accountant cum auditor 2 post, supervisor of estate 2 post, all born under previous revised scale number 9, as equivalent to the post of UDC in terms of finance department memo number so and so. As a result of which, the combined strength of LDC and UDC as on 1/8/2008 under the office becomes 48, and 10% of which comes to 4.8, say 5. So we may agree to create with effect from this retrospectively 1/8/2008, 5 minus 4 is equal to 1. One more post of head clerk in pre-revised scale number 10 under the office of the official receiver, High Court, Calcutta, in terms of memo number so and so, provided that the staff pattern of the establishment from kindly notes 1/8/2008 onwards would be as follows. Now, my lord, they say head assistant, head clerk, 5 post, UDC or equivalent post, 24, and LDC 24. For once, kindly compare this staff pattern with the previous page, page 64. The total now staff strength, is increased now to 53. Formerly, it was 52. And this 21 order, the government passed by the government, is in consonance of the government's original order of 1984, whereby it has to be 1:1 ratio.
सारा दिन उससे अकाउंटेंट सबको यूडी असिस्टेंट के बराबर बाद में कर दिया इसके बराबर नहीं ये मैं चला ऐसा कैसे खबर नहीं आएगा सबसे ज्यादा मिला इसको बेनिफिट सारा हार्डशिप में नहीं So it's question of 1 year.
Yes. Now, what happened, my lord, by the implementation of this order, my lord, the vacancy position, which was originally.
See, there was a decision that accountant, head accountant, and one more posts are to be treated equivalent to UDA.
By means of this order.
According to that, you placed him in the highest.
No, according to the earlier order.
Correct.
2012 order.
2012.
By this order, yes, we placed.
Then your order came that no, it will be treated as LDA.
Lordship, now what happened is that by
now pursuant to this order, you say no, you are treated as
LDA. Because by reason of the
point is
no, well, the staff pattern by reason
whatever may be the staff pattern.
Vacancy position shifted by
nobody is questioning your decision. The issue is the effect of the decision. The effect of the decision is that by your decision, he was made to work on a higher post. By your decision, you say, no, no, now the staffing pattern has changed. He goes to the lower post. Why recovery?
No, my lord.
That's the only issue.
Yes. Now, my lord, since my lord, this was
Why
given on
recovery?
temporary.
Address on this.
No, the promotion was
First
given
of all, what is the period?
1 year.
One
it
year.
was 1st September 2014. Now, pursuant to this order,
1st September
vacancy position shifted
2014.
to- Yes. Now shifted to 1st
September 2014 to
Lordship. 2014.
To which period?
To 1st September 2015. 1 year. 12 months.
So that is the excess payment.
Lordship.
That has been made to him.
Lordship.
This excess payment you have realized in 2021 that you are making an excess payment.
Lordship. 22.
22.
22.
So therefore, after 7 years.
Lordship, because this or by reason of this order, this order changed the entire staff. Not only that, my lord, another
Your case that he has not performed work on the higher post.
Yes, but then the difficulty is, my lord, he says that I have
Sir,
done.
we have understood. You are trying to justify. We are understanding what you are saying. There must be a provision in the service rules that if a person is made to officiate and discharge the duties of a higher post, what will be his entitlement? Where is that provision?
But he.
It's not in dispute that he's worked on the higher post.
You may be revert back.
Yes.
There is no
So what
problem.
is and it is not your case that he has misrepresented or by some deceit he has gone to the higher post. So what is the provision? Where is the relevant provision? Show us regarding officiating period, how it is to be treated under the rules. If the duty discharge is on a higher post and he has discharged the duties thereof, then what does the rule contemplate? Let us see. Where is the provision?
Then I need to check on that.
This is the only issue in your case.
Because this.
See, he is relying on Rafiq Masi, he is relying on hardship. He is saying there is no misrepresentation, there is no suppression on my part. They have taken work from me, now they can't recover. You are saying no, this is the effect of the decision of the
difficulty
having regard to the staffing pattern. Whatever may be,
the vacancy position was not.
We are not on that. We are saying that admitted position, he was placed on higher post by you. Admitted position, you have reverted him. Admitted position, he has worked on the higher.
Yes.
These are 3 admitted positions. Now for work on the higher post, what is the service rule contemplate? Show us. Then we'll decide whether in addition to service rule, something has to be done. Or maybe the service rule takes care of this situation.
May I come back on that? Kindly give me.
Tell us. Then we'll see what has to be done.
Give me some.
Kindly see, I'm just relying 2 pages. Kindly see page 31. My promotion was regularized with retrospective effect. Another thing is this, Lord, the service rule. The service rule, whatever is there, let my learned friend show.
And you will not show.
No, I will definitely show.
So you should also show.
I would rather rely on Article 23. Article 23 clearly speaks. No service rule is required. Article 23 is there.
What does it say?
It will amount to beggar labor.
It will amount to beggar.
Beggar labor. If I am allowed to discharge,
what is the definition of beggar, sir?
But I am allowed to discharge.
What is the definition of beggar? Beggar means work without any pay whatsoever. 23 will not be attracted. That is stretching it a bit too far. Yes. Know what you do on such days.
It is fallen from my letter statement, maybe 22nd.
We know what you do on such days. We'll see.
I will definitely come.
No, I usually, but all through 21st July, I come on that. Those days, I start more early to avoid the traffic. Good.
I'm grateful to you. Look at 2 p.m.
Yes.
I'm grateful.
Item number 15.
Apartment.
Affidavit in reply, my lord. My lord, kindly take up the matter next week, my lord, Monday. Thank you.
That's not a point. It is in relation to compassionate appointment.
Compassionate appointment.
Reply.
Fine.
16.
Make sure.
Exactly.
But may be permitted to file the affidavit with the blind dog. And the affidavit service also.
ফাইল করো ফাইল করতে রেকর্ড করতে
Reply.
Hmm.
একটা নোটও নাই কিছুই নেই
কপিটা পেয়েছো তো রিপ্লাই?
What is the date of the decree? What is the date of the decree?
The date of the decree is there, my lord. That
20th September 2011.
2011.
Then how it has been written 14/5/2005?
And not date of the decree has been passed in my favor. Thereafter, my lord, what has actually happened at your lordship? I don't want to discuss
20th September 2011. That day he has been declared dead.
And he has been declared dead, my lord, civil death. Your lordship remembers this.
What is the date? That's why we are asking you. Why are you saying? We know it is a civil death. But see, father declared dead by civil court on 14/5/2000.
And against that, your lordship.
Here also. Here also. There are many places. 14/5/98. Where is the decree? Where is the decree? There are 3 dates mentioned in the tribunal's order. Where is the decree? 3 different dates of the decree have been mentioned in the tribunal's order.
No, there is only one suit for declaration, my lord, that it will be treated as a civil death.
Where is that decree, sir?
Just a minute.
See, there are 3 different dates. One date is here, one date is here. 8, yes. Cannot be 2005. Let us see the decree. Where is it? Where is the 2011 decree?
Let me check.
আমাদেরকে দিয়েছে আমরা দিয়েছি আমরা দিয়েছি ডিগ্রিটা দিয়েছি না দিইনি ওই ডিগ্রিটা
Yes, 20th September 2011.
My lord, against the decree, my lord, may I submit
20th September 2000. So 11 also. What is his date of birth?
Date of birth, my lord.
What is his date of birth, sir?
He was 11 years old at that time, at the time of the death of his father.
At the time of
his father. Date of birth.
May I disturb your lordship?
Because his father has been missing in 98.
14 May 2005.
May 2005?
14 May
His date of birth?
Of the boy.
How he can be? His father has gone missing in 98.
On the date.
Paragraph, lordship, can you see the OA, page 7? It appears that the candidate Chanchal Muzumdar was minor, 11 years, 5 months old at the time of death. That is on 14th May 2005 of the deceased employee Pradeep
1st November 1993.
Page 7, your lordship.
1st November 1993.
1st November
1993.
93.
He was 11 years, 5 months old at that time.
98. He was.
From where do you get this date, sir?
Copy करने लगा ना उससे.
In the when application was filed.
Of 11 years, 5 months old at the time of.
When she filed application, that document was.
He is eligible. Stipulation.
Are copy আছে?
No, no, you are sure.
Yeah.
Give us a copy.
Left hand side.
Then how is ineligible? How is ineligible?
At that, when a minor cannot be appointed, he was.
Minor cannot be appointed.
But civil to declared in 2011.
So the age in 2011 has to be seen. Prior to that, he could not have applied. Till there was a declaration by the civil court, he was not. Nobody could have applied, whether major or minor. So the declaration comes in September 2011. So the eligibility has to be with effect from 2011. In 2011, he was 18 years old.
May I add 2 things only, my lord?
No, sir, please.
My lord.
Yes.
But they have calculated on 14 May 2005.
How it can be? When the decree is of 2011, that's why we are saying. So he may be short by 2 months because he is born in November. and the decree is of September. He has 6 months for applying. That's why we were asking where is the decree, date of decree. 3 dates have been mentioned by the tribunal.
Lord,
We don't know which is the date.
Lord, he has dragged on the matter up to the High Court, Lord. When I got the decree from the lower court by filing the title suit,
So we can say that for 3 years it was not. So you ask them to consider. Date of death is 20th September 2011.
Yes.
When did he make his application?
Lord, he made application immediately. The mother made the application and the son also. Lord,
We are asking you when.
Lord,
Immediately is not when.
It's written here 17/8/2021 after 10 years.
But according to the records, the boy applied on 14 May 2005.
Huh?
The boy applied on 14 May 2005.
Mother applied on
Maybe he applied.
And that's why rejected.
How can you take your policy says that you are to advise these people who are left in penury and you decided so mechanically.
No,
you should have advised them to make a fresh
2005,
application.
the circular was not born. 2016 circular was not born.
When did you consider his application?
Last.
It was after 2016.
Yes.
What is the date of application? Anyway, he was eligible. So this is a wrong assessment. You have rejected his case by treating him as by taking his age in 2005, which is not relevant. Before civil death, nobody could have applied.
But she has applied and
She may have. She may have, but that is.
Lord, the decree has been challenged and tested up to the High Court in second appeal. Against that decree, they preferred a title appeal, my lord. Failed.
State.
No state. In title appeal, they failed. They have admitted in their affidavit to opposition.
Who filed the appeal? State filed appeal.
No. No stay was granted. Title appeal was dismissed. And thereafter, Lord, the second appeal.
Filed the
They filed. There is not the state filed the appeal.
How they are producing?
And up to the High Court they came. They filed the second appeal. Lord, that is recorded in the order itself, and in affidavit to opposition they have said that we have come to the High Court.
What is wrong with that? That is
No,
a
but the
legal.
thing is,
They have the option in law to do it. They have done it.
Lord, up to the High Court they have come.
to be admitted under order 41.
Order 40 was ruled
Whatever
11.
it is to be considered keeping in view this date. 20th September 2011.
Date of decree.
Decree. Before that, it cannot be considered.
Yeah.
There is no way. If it was a case of natural death or unnatural death, it could have been considered. But this is a civil death. So this, unless there is a declaration, there is no death. There is
What are
no
the evidence?
the compassionate appointment cannot be invoked unless there is a death.
7 years they have to wait.
And correct. Before the declaration, they have to wait 7 years.
7 years.
So you consider it taking into consideration this is the date of death. And in 2011, which EMP was applicable? 251.
Just give me 1 second. 2011.
Yes, you can.
Oh no, not 251. 2008. 251 is of 2013.
2013.
251 will not apply. So 2008 EMP 30.
2008 circular, that is 39.
EMP 30.
Yeah.
So what was the time at that, the limitation for making application at that time? 6 months.
6 months. So long. 6 months. 6 months.
So he could have applied till March 2012. And by March 2012, he has attained the majority.
Then the fresh application has to be made.
He will now submit everything.
Fresh application.
Yes, but he has to be treated as eligible. Can't be treated as minor. Now he cannot be made to suffer for this lapse of time. This mechanical order has been passed, to say the least.
I do not know what is the age.
Today, what is his age?
Now, if more than 27 years, then we will.
His date of birth.
More than 27, more than 40.
93, his date of birth.
For compassionate appointment is 40, sir.
Police constable 27.
Huh?
Police constable 27.
Now he is 43.
Police constable, if he cannot be appointed in the exempted category, you will have to consider him other. That is your rule. Either in exempted category subject to fulfillment of the eligibility or elsewhere.
32. 32. Date of birth is 1st of November 1993. And in year in 25, 32, 5 months, 32.
If they don't qualify,
Where is the rejection order? Authority's rejection order?
Order dated 21st of August 2023, Lord.
Can you give us the page, please?
Page and
August 2023.
Which page? We will want to see it there.
Opposition, page 9. Every opposition, page 9.
Which page? 67.
When you have filed the application for
let's try file the application.
appointment, you come to page number 67.
67 of my application.
Of your application. You have made an application on 17
August 2021.
After 10 years of
Civil
degree,
death, civil death.
Lord,
why such delay? So you did not any constraint of any money or
Lord,
financial help?
may I make one humble submission?
Yes.
Actually, my Lord, a departmental proceedings was started also. My Lord, and
That
he,
ended in 2014.
no, and he was, my Lord, he was treated
The
as
authority has already declared that dismissal order to be void.
and that has been challenged. That was challenged. That has been set aside by the court.
2014.
Yes, that has been challenged.
When it was set aside?
My Lord, it has been set aside, my Lord.
Even
Page 63, not just page
7 years. 7 years.
There was a dismissal. Page 63, my Lord.
Let us see what is the date. Let us see what is the date. 60? Somewhere I have seen 2014. I don't remember where I have seen it. Maybe it is
63, my Lord. The order passed by the learned tribunal. Accordingly, there is no registration.
Which page?
Page 63 of my application.
What is the date? Just give us the date of this order.
Order of the
Oh, it is 2020. 4/9/2020. Then 4/9/2020 is the date of application.
September 2020.
What is the date of? And the application is dated?
17th August 2021. 17th August 2021.
Filing application was 2 years. So in 2020, the application time was 2 years.
2 years.
No. If my lord, 2008 circular, 6 months.
No. How that can apply to him? Cannot apply. The decrees of 2011, but he could not apply because the dismissal order was there. So there were two obstacles. One is the decree
of the civil
and
court.
the other obstacle is the dismissal order.
Dismissal order set aside
in 2020. So
2020.
only thereafter he could have applied.
Thereafter,
Before that he could not have applied. And after that he has applied within
11.
less than a year, less than 1 year.
Also 43 years. 43.
What is your age now?
Now 32.
32 or 43?
Date of birth, Lord. Date of birth is 1st of November 1993.
Then how you are saying 32?
2025 minus 93. 32. 32 years.
How it is 32, sir? 21 years in this century only.
25. We are in 25. 1993.
17.
32.
25 and 17 years. 7 years. 7 years. 32.
He is still eligible.
Date of birth.
Yes. After 2 decades,
They have dragged on the matter.
that is all right.
They have dragged on the matter. Lord, the legal tangle, Lord, they have dragged on me up to the High Court. Lord, twice the order was passed, I was given the benefits, etc. Then second appeal, this and that, and nothing happened. Everywhere they failed. At all forums, they failed.
Other aspect to survive. There is two kinds of things. So I'm asking you, you will not.
I have not failed, Lord. The system has failed. They have dragged on the matter years together. In decree challenge, appeal, title appeal, then High Court second appeal filed, not admitted, nothing. It is pending. They have said that it is still pending.
Why are you again and again saying
I'm not
about
saying all these
appeal?
things,
How
but-
the appeal is relevant?
Lord,
How it is relevant? Tell us.
not at all relevant.
Then
They have stated-
repeatedly you are saying first appeal, second
Lord,
appeal,
they have
as
stated
if
so.
they have committed some crime by
They have
filing a
stated
first
in their
appeal and
appeal to
second
opposition
appeal.
also.
Let them file. How does that affect your claim? That does not affect your claim. You are unnecessarily
Very well,
repeatedly saying
Lord,
that
I'm sorry for that.
first appeal, second appeal means nothing. So which application they will consider? 2000. So now into this 2016 circular says 2 years.
Yes, 2 years.
What is the EMP number?
Just give me one second. EMP number 26 EMP.
Opposition
Page
আছে।
51
Opposition
of my
কত
opposition.
লাগিয়েছে?
March 2016.
Yes.
Page 32. Clause 10A.
No, EMP at page 26.
31.
No, this is 2006. We are looking for 2016 one.
2016. The page 31 of the opposition.
No, we are looking from this compilation.
No. In opposition.
Is there?
Yeah. Page 31.
Respond number 5.
Yes. Paragraph 10A, page 32.
Timelines
Time limits.
within 2 years from the date of death.
Yes, from the date of death of. That means declaration by the civil court.
And where is this order of 31/10/23, the rejection order?
31. Page 9 of my opposition.
That is only wrong.
The date of death, 14/5/2000.
Yes, take down.
আপনি কি করছেন?
Seventeen.
For the state.
Not today, my lord. Led by my lord, I am praying for not today, my lord, led by Mr. Loknath Bhattacharya. All right, not today.
Not today for this.
18.
My lord, I am appearing on behalf of the petitioner, my lord. There was a direction upon the respondents to file an.
Opposition is filed.
I have not yet received any opposition.
Well, Kali, extend for 10 days time, maybe.
3 days.
10 days time.
Time for filing of.
Good assist.
Nineteen.
There are exceptions. But bulk of it is. This we have considered.
Let it come before that, since we have heard this for some time. Monday? All right with all of you? Yes, as jointly prayed, list on.
Some matter for judgment.
Twenty-one.
I appear for the respondent. The matter, my lord, where your lordship has seen that the charge is vague, my lord, that is
Supplementary, who is to file the supplementary?
supplementary, my lord. The documents which we have filed before the SAT, my lord, those were not annexed to this application. And I have handed over the bunch of the supplementary affidavit, my lord, filed before the court. That was handed over. Your lordship is directed to file supplementary affidavit upon the petitioner.
Where is the writ petitioner? It is a state writ petition.
Right.
Nobody is appearing. You have to file a supplement. There is none to represent the state. One week we can.
1 week.
1 week.
Grateful, Your Lordship.
Twenty-two.
None appears on behalf of the petitioner.
Twenty-three.
'Everybody is gone. Not today.
24.
Lordship, I am on behalf of the petitioner. Advocate on record is out of station. Kindly grant to not this week.
Not today. Kal not today. Discuss.
25.
I am for the applicant petitioner. Other side, Mr. Bosu Mollik.
Mr.
Bishopbodha Bosu Mollik, learned AGP is there.
Is he?
Then selection process, medically I was fit, certificate given by the district medical officer, 59% disabled. Now my process done. I was in the panel. At the time of recommendation, fresh verification, but they have sent to another medical doctor. Another medical doctor opined that I am the 30% disabled. Whether this can be permissible in terms of the new rules, 2016 rules, but process of selection in terms of the Disability Act 1995. That is the issue. and they cannot change the eligibility criteria.
No, but what is the recruitment process? Does it contemplate a verification of the
1990 rule mentioned in the advertisement itself.
No, it says that there will be a verification of the claimed disability.
Yes, and another point, in terms of the rule 20 of the 2016 rules itself says that if the document is valid in terms of the earlier rule, then it is valid for 10 years. So on the basis of that, I am entitled. And that too, they cannot change in the midst. That is the issue. And that has not been dealt with. In the opposition, they have said, since it is a new rule, it is to be followed during the process of selection. And change of procedure cannot be done in the midst of the selection process. That is, let it be on Tuesday, 15, I am informing him. And I am covered by judgment of coordinate bench of your lordship. Justice Chakraborty held. Same authority cannot opined, already opined by another same authorities. It is the appellate authority, they can revive or revise or anything. But
no, the first thing is whether the recruitment process contemplates
mentioned
that
advertisement mentioned
the certificate of disability submitted will be subject to a scrutiny. If it contemplates, then of course it can be done. If there is no
can be
contemplation,
done, but in terms of the old rule itself, because old rule governs the field. In terms of the new rule, it cannot be done. And that too, division bench held the same authority at the time of fresh verification. It is a verification, not the same again testing of. That is the cracks of difference.
verification means just to establish the document whether it is genuine or ingenuine.
Yes. And authority has given that certificate and valid for 10 years. Whether that validity can be questioned in the
Examination does not mean fresh examination.
Correct. Correct. And I am obliged to your lordship.
Medical board given the certificate.
Yes. Medical disability certificate. 1999 rules will be governing that.
Certificate must have been valid, otherwise your candidature would
Yes,
have
up
been.
to the recommendation.
Huh?
Maybe. Maybe, but it is still late in terms of our judgment of the Supreme Court and division bench.
No, but if it is state, then we cannot
Subject to
rely on that.
correction.
Then we
If it
can't
is
rely
state,
on
it between inter se parties. But same view to be followed 2013 2 SCC Malad says.
Okay.
All right, we are coming. If that point arose, then I have to cite that judgment.
Yes.
Same to be followed, subject to result. Obliged to your lordship. But 15 then. তুমি জানো ওটা স্টে করেছে যে তুমি ছিলে তো সাবাস তুমি কোথায় নেই বলো দেখিনি হি ইজ অলওয়েজ এভরিওয়্যার যা জাজমেন্ট খুঁজি সব দেখি স্টেটে রয়েছে তপন দা পারি না রাখতে আর
What have you said? What have you said?
Oh, whatever the judgment I find, always Mr. Mukherjee's name in respect of this type of matter.
He is always on his toes.
Always.
Yes.
Always. There should be some restraint.
List after 1 week.
করে নিয়ে দিয়ে দাও এবার ওই দিনকে দেবো let it be on Tuesday.
We have adjourned it 1 week.
1 week. 1 week. And I'm informing Mr. Busumalik. Just now I have informed. He's maybe busy in another court. Grateful. 17th. Okay. উপরের দিকেই থাকবে তো একটু হ্যাঁ নিমোশনে থাক grateful to
26.
26, I am paying for not today, my lord.
Yes.
27.
For the this is my affidavit service only.
Some cases, other persons also appear, but mostly it is there.
But this is my affidavit service.
One day he asked me that it's a special day for state tribunals. No, that is sorted. Great.
Yes, I have served, my lord. I have got the affidavit service, but my lord, one copy, my lord, my
Not required. Tell us what is the issue.
But the issue involved, my lord, I joined my lord medical service in the year 1984. Then, my lord, in the 1991, I joined my lord education service as demonstrator. Then, my lord, what happened in the year 1997, my lord, I opted for my lord, my masters in pediatric, my lord, and during my service, my lord, and approached before the authority concerned for TR scheme, Tenny reserved scheme. That was not given to me. I was not favored with. Then, my lord, I approached before this Honorable High Court with the plea that so that I can be considered as Tenny reserve candidate during that period. So, my lord, in the year, my lord, 1998, my lord, there was an order passed by this Honorable High Court, my lord, in the writ petition 8552 of 1997, directing the respondent authority, my lord, to consider me, my lord, under Tenny reserve scheme, to favor with that scheme. Then, my lord, because of my lord, departmental flaws, my lord, that was awarded to me or favored me with that privilege of TR scheme in the year 2012. So, my lord, during the period of 1997 to 2000, these 3 years, my lord, my all increments, my promotional benefits, my consequential, my lord, increments, and everything, my lord, withheld. So that was supposed to give in terms of
all of that has been given to you. The issue is whether you are entitled to CS benefit or not.
My lord.
That is the only thing.
My
You are giving the entire history.
My lord.
Whether you are entitled to CAS benefit.
Career
What is the scheme? Your last promotion is of 2000.
My lord.
As assistant professor.
My lord.
Next promotion was due in 2004.
My lord.
And professor in 2007.
My lord.
These are the 3 dates.
My lord.
Now, why you should get a CAS benefit? Tell us.
Because during that period,
what's the scheme? What is the scheme?
kindly takes up paragraph page 50. Fif- 51 the Gazette, West Bengal Government, MES. And CA scheme, I am not carrying it. May I
This is not the rule. Only issue is benefit of CAS.
Yes, career advancement scheme.
So where is that scheme?
I am not carrying today because it has not been annexed with my petition. So
We have to see that whether you
my-
are entitled or not. That's only.
that is
Come
only-
tomorrow with the scheme. Not-
May I come back on Monday, if you lot.
Let it come tomorrow. Come with the scheme. Let us see.
My lord.
Not today. Yes.
My affidavit service be kept with. Let affidavit service be kept with there. Affidavit
Come tomorrow. Come tomorrow.
as well.
My lord, I am appearing on behalf of the Public Service Commissioner led by Shravani Sarkar. Ms. Sarkar have some personal difficulty, so adjourn for that.
Not today.
I am absolutely wrong impression. I find that it is supplementary. So I was under impression that supplementary list means some list to be published. But I don't have that idea that his lordship has taken up this daily list as supplementary list. So I have some matters where I miss everything.
Where it is showing supplementary.
Yes, but in the board.
No, this ADSL.
ADSL. That
Rightly
means,
said.
my lord,
Rightly said. This is a supplement. ADSL. ঠিকই দিয়েছে তো।
না কিছু ঠিক দেয়নি।
But it should not say
আরে বাবা এসএল থাকছে না এসএল থাকছে ওর সঙ্গে
সাপ্লিমেন্টারি
ইয়েস সাপ্লিমেন্টারি এটা সাপ্লিমেন্টারি লিস্ট কি বলছেন it should be right as AD
it should be AD. Why supplementary?
The daily list is following.
AD.
দেয়নি তুমি না জেনে কথা বলো না তো বসো তো উল্টোপাল্টা কথা বলছে
Was supplementary.
এক্স্যাক্টলি সেটাই তো বলছি আমি এডিএসএল দেয় না এডি এখানে লেখা ইয়েস
But if you want, you can say AD also. If you want, you can type AD.
জানি না তো কি হলো ওটা
No. This is being followed everywhere. Your court's practice is that if a supplementary list is published, like today, this is a supplementary list. This is not the daily list.
Actually, what happened, my lord, it should have been published, my lord. If supplementary is published, my lord, that would be in the website, so that we shall get hold of.
It's not there.
I don't think so, my lord.
Don't say don't think so.
No, ছিল আজকে মানে his lordship is it a daily list, my lord? Now in the daily list, my lord, it always mentioned as AD1 like that daily list.
What they are telling us, I don't know your system.
I just checked, my lord.
Because this list we are taking up, but this list is not the number is from this list.
Here, my lord, the notification of supplementary cause list dated 10/7 appellate side court 3, not court 4. That supplementary that has been published. Now, my lord, in the board, my lord, even in the
No, regarding
also,
court
my lord,
4, court number 4, there is no notice.
nothing in the website. This is the High Court website, my lord. And in the board, my lord, it has been mentioned appellate side supplementary list.
Why there is no notification of this supplementary?
29 when 29 when.
Item number 29.
My lord, I appeal for the petitioner, my lord. My lord, this is a case of a petitioner. The petitioner before before your lordship is a doctor, my lord, who tendered resignation. Now, my lord, thereafter, my lord, he moved the learned tribunal. My lord, the midst of hearing before the learned tribunal, my lord, the authorities produced one letter, a show cause letter, purported show cause letters, which was never served upon me. My lord, till that day when the matter was placed before the learned tribunal. My lord, learned tribunal, on the other hand, my lord, taking
It's absent from 8 January 2020.
Yes.
My lord, in entire cases, this, my lord, the petitioner, but this purported show cause notice was never ever served upon me, so I was not in know-how of the show cause notice. My lord, be that as it may, my lord, I may further say, my lord, even the rule provides, but if your lordship takes up, my lord, rule 34A1, my lord, note part, my lord, it says, my lord, the period for which, my lord, if I tender resignation, my lord, there will be a period for which, my lord, notice period is there, my lord. That depends upon the person been holding a confirmed or been a not confirmed employee.
Where is the provision for resignation?
Well, rule 34A1 of the WBSR part 1.
Thirty-four.
34A, my lord, capital A within bracket 1.
That has been amended in 26th August 2016.
আমার ক্ষেত্রে applicable না স্যার আমার ক্ষেত্রে applicable
Oh, there is now an amendment for
the
people
amendment
serving in the
5 years. Amendment says, my lord, a doctor cannot tender resignation provided he has a service less than 5 years, taking all the service together. Now, my lord, my case, my lord, I joined in the year 2008 in West Bengal Health Services as a doctor. Now, my lord, thereafter, when I shifted to West Bengal Medical Education Service in 2018. So, my lord, the period I served from 2008 to 2020, my lord, that amendment is practical of no consequence in my case.
Unauthorized absence is a misconduct.
Huh?
Unauthorized absence is a misconduct.
No, but where is the bar in the rule?
But if somebody does not attend the duties regularly, then when unauthorized absence should be treated as a misconduct.
No, but he is not claiming VRS. He is not claiming VRS. He is claiming forfeiture of his service.
Forfeiture of his service.
Resignation means forfeiture of service.
Forfeiture of resignation.
No. Resignation means forfeiture of past service.
Past service.
So he is seeking forfeiture of his past service. In that, is there any provision in the rule for that also? There has to be no proceeding pending.
Before releasing anybody from government service, there should not be any departmental proceedings. There should not be any vigilance commission.
In resignation.
Even the resignation.
Where? That is what we are saying. Show us from the rule. In VRS, we can understand, yes, this requirement is there because he will be entitled to benefits. He will get pensionary benefits. But for resignation, where is this requirement? Because he will get nothing the day he leaves. And if there are some dues, then you may ask him to pay it at the time of resignation. If he is carrying some dues, because he will require no dues at the time of resignation. There is no dues. There is no proceeding pending.
In that even kindly give me some.
Huh?
In that even kindly give me some paper.
When?
Next week.
Monday? Monday is all right.
Monday couldn't say, Monday.
Tomorrow is a Friday. Nobody will be available after 5 o'clock.
Let him.
Monday week.
Monday.
Monday week, Monday week. Monday week, sir.
Monday
Malad, you also kindly consider, Malad, I have to, Malad, to leave station, Malad, to get my license, Malad, renewed. Malad, my license is in Punya, Malad, I have to go to Punya, Malad. So, Malad, Monday week I will be a problem, Malad.
1 week.
Well, Monday week I will have a problem, 21st, Malad. That day is because normally all these things.
When do you want? Tell us.
I want Monday, this Monday itself. My learned senior friend doesn't have an issue, Malad. I don't have an issue, Malad.
What are you saying? Monday week?
No, but this Monday we will not be able to get completed.
Then Tuesday, Wednesday, any day?
Thursday.
Thursday. As paid.
Service plan.
Affidavit of service taken on record.
Thirty.
But 30 is also application, my lord.
Same.
No, my lord, it's not resignation, my lord. Matter relates to, my lord, study leave. Matter relates to study leave.
Study leave.
Study leave. Now, my lord, the petitioner, my lord, got admission in a college after, my lord, getting my lord, to pursue a my lord, diploma course. My lord, he approached the tribunal. Tribunal, by its order dated, my lord, 25th June 2025, simply, my lord, adjourned the matter, my lord, without going into any thing regarding that. But it only says by filing this application, applicant has paid for a direction respondents to allow him to pursue a certificate course in neuroradiology by
They have
granting
rejected
study.
your claim.
No, my lord, there's no claim has been rejected, my lord. Now I'm in a limbo, my lord. The course have begun.
When have you made an application for this?
Yes, ma'am.
Study leave.
Yes, ma'am.
Page 50.
Huh?
The presentation is at page 50.
50.
50, my lord.
So in April, you have made an application.
My lord, my lord, the authority says, my lord, I have to be get myself admitted by, my lord, 25th of March. My lord, I got admission, my lord, if your lordship takes up page 45, 44 is the.
So before admission, why did you not apply?
No, my lord, I had to get chance.
After taking admission, after 1 month thereafter, you applied, and all of a sudden you are in a hurry.
No, my lord. But the rule says, my lord, service lordship kindly, my lord, I will also take instruction if your lordship allows me to say so. My lord, it's a not a, my lord, it's a NEET PG that I will getting, my lord, for a, my lord, post-graduation course. It's a diploma course, my lord. First of all, I have to, my lord, get a rank to get a chance. Unless I get a chance, my lord, the question of granting or applying for the study leave becomes meaningless. I applied, my lord, for
When
NOC.
did you get the rank?
My lord, yes, my lord. I got the rank, my lord. I got the chance in, my lord.
Before you got a rank, the admission could not have been confirmed.
No, my lord, that's true. Absolutely not. Page 41, your lordship kindly takes up.
Only
That
after
is
that
dated.
admission will be confirmed.
My lord, 18th of March 2025, offer letter was given to me.
That's not what we are asking. Once you got a rank, you should have applied for a study leave. You knew you were going to get admission. Why should you wait and precipitate such an urgency and then come to the High Court for everything? We don't appreciate
No, my lord, your lordship kindly takes note, well, earlier I have done.
Unless
Page
you
39.
Unless you show due diligence, where is the question of High Court coming into it? Cannot.
My lord, if your lordship kindly takes up, my lord, page 39, this is the NOC by which I applied for, my lord, to pursue the course.
Maybe that's not the point.
Well, thereafter, they granted me the NOC to, my lord, to take part in.
Thereafter, you have waited for 1 month to approach the tribunal. Even later, 1 month for making application, and then we don't know when you have approached the tribunal. You are sleeping over it.
My lord, may I come back tomorrow, my lord, or my lord, Monday, my lord, let me take instruction.
For
Come back.
what?
My lord, there are certain
What
documents,
instruction?
my lord, only for Monday, my lord. Your lordship kindly consider this. Let that be on Monday, my lord. In Monday, your lordship may take.
Tomorrow, whatever you want to say, no Monday. Sorry.
As a lordship. Deeply. Wait.
Item number 51. Item number 52. '53. 54. 55.
56.
56.
56, my lord, I beg to appear for the applicant. Petitioner. This is that matter, my lord. The PET is in question, my lord. My lord, on the last occasion where the matter, my lord, that relates to age bar, my lord. My lord has fixed on 28th that it relates to. My lord. My lord, all the affidavits have been exchanged and all.
Let him be here.
Yes, because my lord had specifically asked them a question because.
Let him be here. He is not here.
My lord.
How he will answer unless he is here? All the next.
57.
57 also is the same one.
58. 59. 60. 61. 62.
My lord, I am in the item number 57. I am praying for short passover. My senior is outside. He is bringing the files. Yes.
Your senior is?
Coming. He is bringing the file
On his legs.
on his way. Item number 57.
He is coming.
Ask him not to come. It is already adjourned. Ask him to come tomorrow. Yes.
Thank you, Lordship. Grateful, Your Lordship.
63. 64. 65. 66. 67. 68. 69. 70. 71.
71, my lord.
My lord, in this matter, we are for the petitioner, my lord. Hearing is very necessary. We have already mentioned for upgradation, my lord. If my lord, in next date, if it is upgraded something.
It is urgent and next date also. Both. Argue right now if it is urgent. What do you mean next date?
My lord,
Case has been called and you are saying,
opponent is not ready to.
let us see, you argue. You argue.
My lord,
Forget about the opponent.
So passport is necessary. My lord, senior is just coming. My lord,
You start.
No,
Give
5
us
minutes.
the
My lord,
file.
5 minutes is necessary.
Give us the file.
5 minutes is necessary, my lord. I have just called him to. My lord.
It is very urgent. Fix it. Both things.
T26.
5 minutes is necessary. 5 minutes. এদিকে তাহলে ফোন করে দিচ্ছি
Yes. What is so urgent?
বসো বসো
চলে গেছে হয়তো দেখছি My lord,
Yes.
my lord, senior is just coming, but there is no time, my lord. My lord.
Not today. The next. Room 85, 86. So about direct payment. Right, the corruption. India का लेटर पे रिलाई करता है कहता है टेम्परेरी कैजुअल डेजिग्नेट कभी नहीं पेरिनियल वर्क है ऐसा भी नहीं है क्योंकि रिस्पोंडेंट्स का कहना है कि ऐसा कोई कानून हमारे पास नहीं डे टू डे बेसिस पे इट्स राइट
Item number 73,
Just 3 minutes.
74, 75,
'Call the next.
76, 77, 78, 79,